Good afternoon. This is the House Judiciary Committee. It's still, hello. It's the House Judiciary Committee. It's Tuesday, the 4th of February, 2025. We have a number of bills, including the first bill with House Bill number 5, Delegate Wilson, Chairman Wilson, that guy, who is here. And you have one other, so I'll take it whichever way you'd like. There are a total of 4 people here to testify. One of them is virtual, Margaret Durkin. If you want to have Ms. King come up, she's favorable with amendments. Is that okay? Come on up, and Ms. Jordan. Okay, that's fine. And she's there. All right, that's fine. So, Chairman Wilson, please. For 3 minutes, everybody else for 2. Judiciary Committee is still,
Does that count on my time? Good afternoon, Chair Clippinger, Vice Chair Bartlett, and esteemed colleagues in Judiciary Committee. I stand in support here, bring today House Bill 5, which expands the definition of child pornography in Maryland's criminal code to include AI-generated content. While artificial intelligence offers many benefits, including misuse of, it also can be used to create realistic computer-generated child sex abuse imagery. These images, though artificial, cause real harm by fueling the demand for exploitive content, enabling offenders, and re-traumatizing survivors. Maryland's current codes do not explicitly address AI-generated imagery, create a loophole that HB5 aims to close. By modernizing our laws, Maryland reaffirms its leadership in child protection and sets a national standard for addressing AI-generated exploitation. The intent of HB5 includes a proactive protection to ensure that the Maryland law explicitly covers AI-generated content and prevents offenders from exploiting gaps in the legal system. While AI-generated images do not depict real children, they normalize and encourage the consumption of child sexual abuse material, putting real children at risk. By acting now, Maryland stays ahead of the curve in protecting children from emerging digital threats. HB5 is more than just a legal update. It's a moral imperative to protect children, both physical and digital world. By closing this loophole, we send a clear message. No form of child exploitation will be tolerated. I urge my colleagues to join me in supporting HB5, ensuring Maryland remains a leader in protecting our most valuable children. I do have, and you will hear, there are people testifying in favor with amendments. I do have to create there's an amendment on file which just strikes child pornography and substitutes child sexual abuse imagery. I have to send an additional amendment, and I ask that you strike that. And I will try to, it will be amended to say child sexual abuse materials. And this will be in line with federal code, throughout the federal code, and I'm going to ensure that that's replacing child pornography throughout this entire bill with the words child sexual abuse materials. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 5 with the sponsor amendments. Thank you, Chairman Wilson, for your continued legendary leadership in the area of ending child sexual abuse in Maryland. I defer to the committee whether you want to add the phrase artificial intelligence or you believe that computer-generated image is sufficient, and I know that my colleague Ms. King is going to comment on that. I do really want to thank the sponsor for adding child sexual abuse materials instead of child pornography throughout the code. This is a modernization of our language that sends a clear message that pornography is not something that is consensually created and it is a product, but these are actual pictures of children who are being sexually abused and harmed. We need to keep our focus on those kids and use the appropriate language. So for these reasons, we support House Bill 5 with the sponsor amendments.
Good afternoon, Mr. Chair, Madam Vice Chair. My name is Joyce King. I am Chief Counsel at the Frederick County State's Attorney's Office. I'm here on behalf of the Maryland State's Attorneys Association in support of HB5. Thank you, Chair Wilson, for championing this topic. I've been a child exploitation prosecutor for 12 years, prosecuting child pornography crimes with our task force in Frederick as well as in the federal system. I echo the sentiments of Ms. Jordan. Under the current statute, I'll defer again to the committee whether or not the language which AI is necessary. We have been able to proceed with under the existing language of computer generated. However, the sponsor amendments, I really, on behalf of the victims that are known and unknown, this is an important change for those victims to call this child sex abuse material. Like Ms. Jordan said, I mean, these are not just images, but also videos of child sex abuse, of child rape. And having spoken to these survivors, it's important for them to be acknowledged in this way. There's a great minimization of child pornography victims and these types of crimes, that these are often unknown victims, international victims. And I think it's important to prioritize this to make sure that they're heard and recognized as abuse victims. So with that, we support HB5. Ask for a favorable report.
Mr. Chair.
Yes.
I just wanted to make sure the committee understood my was to amend the words child pornography in 11-6207 and take out the words child pornography and throughout the code and amend them with, what's the word again?
Child sex abuse material.
Child sex abuse materials. I just want to make sure that that would be the intent of the amendment. It's not in front of you. It's not just in my bill. It'll be throughout that code.
Margaret Durkin.
Good afternoon, Mr. Chair and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a technology trade association. Thank you for allowing me the opportunity to speak today on House Bill 5. TechNet's members are active in developing protections against the creation, storage, and distribution of child sex abuse material, or CSAM. Our members also assist with law enforcement when the time arises in combating this material online. We appreciate the intent of this bill and are coming in as favorable with amendments. We want to ensure that the bad actors themselves are held accountable and not necessarily the platforms that they may have used to distribute such material. As such, you will see some suggested language in our written remarks that places the liability on the bad actor and exempts any interactive computer service per Section 230 in federal statute. We also believe that any bill should consider and exempt any work being done to prevent the creation and distribution of child sex abuse material, and our suggested language is also in the letter. Finally, in terms of knowledge, we believe that any strong bill should have both a actual knowledge and intent standard. So we're suggesting on page 2, line 17 of the bill to change that "or" to an "and." Thank you for the opportunity to speak today, and I'm happy to take any questions.
Yes, thank you, Mr. Chair, and a very good bill, Mr. Chair. The Chair Wilson, that is. So my question is, TechNet, have you had a chance to read their written testimony? And if so, do you consider their amendments friendly, or do you think you'll work with them? Or if you haven't, I'm happy to drop off their letter with Ms. Jones after hearings today so you can review it.
Well, I have not written. I do believe that there has to be a standard that we set throughout the country, and I do believe that it's responsible of the providers of the services as well as the creators of the imagery when it comes to this, because they have to police themselves and they have to be incentivized to do so and to hold completely harmless. Again, this is your committee, so I understand you will do what you choose, but I don't feel that necessarily holding them completely harmless is the correct avenue if we want to eradicate this disease that we have in our community.
I agree with you. I just wanted your assessment on their amendments. Thank you, Mr. Chair.
Thank you, sir.
Delegate Grammer.
Thank you, Mr. Chair. Can you articulate for me one more time the need and the ramifications of changing the term child pornography to child sex abuse material?
I will let the folks who pointed out.
Ms. King.
Ms. King.
Thank you. Thank you for the question. This is an important movement on behalf of victim advocates in the National Center of Missing and Exploited Children. Many states are moving in this direction. When this crime was initially enacted, it was called child pornography. And the term pornography insinuates that the child is consenting, that this is some sort of actual industry, and it's not. We have to we should call it child sex abuse material because that's what it is, the images and videos of children being raped. So it's important for victims and it's important for the community, so there isn't this minimization by the judicial system, by the community, by tech companies, that this is some sort of separate entity. These are real children in these videos and images.
But it doesn't change the way it's prosecuted or what we're prosecuting?
Correct.
Okay, thank you.
Vice Chair.
Thank you, Mr. Chair. And I have to follow up on that question, Ms. King, and thank you, Mr. Chair Wilson, for bringing the bill. So I want to make sure that, and I was looking at the national information, I want to make sure that there's not a threshold, and forgive me my ignorance on this one, okay? That there's not a threshold of abuse that has to be met, and then the threshold of what one would, have as sexually explicit material.
No, that's a great question. It doesn't change the legal standard or what we need to prove. This committee and this body actually changed the law to include the lascivious display of genitalia as well. So there's no requirement that there needs to be any hands-on or any sexual act, because even the lascivious display of a child is exploitation and still abuse.
Okay. And then the second question is, do we have to, and have you already talked about, do you have to define child sexual abuse material in the bill?
We would not. It would just assume the existing definitions of child pornography.
Okay, thank you.
Thank you, Mr. Chair. Thank you, panel. Briefly, you said that these are real children.
Just obviously, in most sets and circumstances, yes. In this specific, but throughout the code, yes. In this specific set of circumstances, no, they are computer-generated children. It's just to be consistent throughout the code, and this will be interjected into the code, the AI generated, because while they may not be depictions of real children, they have generated, for all intents and purposes, images of children. So while this specific bill deals with computer-generated images, which ergo are not real people, however, the same would apply. We want this to apply throughout the code.
So if you were looking at something that was harmful to children but not pornography, that could still be brought into question under a similar type situation? In other words, if you're looking at a cartoon and it's showing pornography, and you're looking at a cartoon and you're looking at a child being thrown out of a window or something like that, well, I think that they could be, one step leads to another, the slippery slope, as they say. Would you agree with that possibly?
I believe, well,
Not under this existing
I know
code,
that.
but
I just articulated that, but yes.
we understand it.
I'm
Again,
for your bill. Thank you.
because I will say that, the slippery slope, that's why we're here.
Yes, sir.
We get to stop at any point. We stop that whenever we choose.
Yes, sir. Thank you very much.
Thank you.
All right, seeing no further questions and no further witnesses, that concludes the testimony on House Bill 5. Thank you very much. Thank you very much. Now we hear from someone who is a distant memory now to us. Distant memory. Someone who used to be our friend. Used to be our friend and spend time with us, but now it's off to bigger and better things, I suppose.
I'm still your friend, Mr. Chair.
All right. Well, it's very nice to say, but,
And I mean it.
Delegate Robertson, do you have a panel that you'd like to have join you? Four others?
I believe so. If there are any in support of.
There are 4 others who pick
HB445.
4, and we'll work through
You
the
can
rest
come
of the
on up
list.
if they're here. Anywhere you'd like to sit. Yep, that's right there is fine. Thank you.
Okay,
And you
that's
all-
fine.
Thank you.
All right,
And-
so what we'll do is we'll hear from Delegate Robertson, and then for the witnesses, it'll start from my right to across the board. Just ask you all to identify yourselves on the way. Delegate Robertson, please, for 3 minutes.
Yes, sir. Thank you, Mr. Chair. And I'm just going to ask, just for the record first, that if there are any panelists that if you can say me too, since there are a wealth of people, we can shorten the time because the committee is very much aware of this bill and very much supportive in many ways. That being said, for the record, I'm Delegate Kent Robertson here speaking on HB401. And first, good afternoon, Mr. Chair. Good afternoon, Madam Vice Chair, and good afternoon to the hardest working committee in the Maryland General Assembly, the Judiciary Committee. It is so good to see you all, friends, and we appreciate all the hard work that you do to continue to make the General Assembly function. That being said, I'm here to speak on HB401, which deals with jail phone calls and allowing for it to be free. And I will read what my intern wrote. So if any issues, please file it with IEMA. Thank you. There is no mistake that Maryland has one of the highest incarceration rates in the nation. People who are incarcerated in our state have been exiled from society to atone for their actions and rehabilitate their behavior. However, their sentences should not resort to disconnecting them from their families as a form of punishment. Incarcerated individuals are already subjected to low-income jobs and limited family visits. HB 401 seeks to subsidize the phone calls between incarcerated individuals and their families so that cost will no longer be a barrier to this communication, as well as mitigate the consistent bludgeoning reminder of the lack of presence of individuals within families. As a legislative body, serving the people, it is imperative to take into account financial as well as mental trauma from our constituents. This bill will not only help reconnect families that cannot afford to pay for these calls, but it will also remedy the effects that wealth inequity has within the prison system. Phone calls serve as a pathway to restoration, allowing individuals to stay up to date with events and inspiring them to continue their personal transformation. I humbly and confidently ask for your support in getting HB 401 passed, and I realize that there is a large fiscal note attached to this bill, and so we take that into consideration, but we continue to advocate for those individuals, whether we are in financial constraints or not. We want to make sure this continues to be a conversation that is being had here in the Maryland General Assembly. With that, I thank you for the time and yield the remainder, and we can begin with the witnesses.
Good afternoon, Chair Clippinger and House Judiciary Committee members. My name is Penny Barnett, and I'm here to speak in support of HB 401. In 2023, our son was arrested for behavior that was caused by severe mental illness. Our experience during his intake and incarceration convinced us that communication between incarcerated people and their family and friends is very important for their mental health and rehabilitation. Furthermore, the harm caused by lack of communication decreases the chance that the incarcerated person, when released, will resume life as a productive citizen. I believe that the difficulties communicating with family and the potential consequences of failure to do so are faced by many, and I strongly urge you to vote yes on HB 401 to make phone calls from prisons free for incarcerated Marylanders and their families and readily available. In 2023, when our son was arrested in Montgomery County, the lack of transparency about the process for communicating with him meant that while our son was in crisis, we were unable to reach him for 2 days before somebody finally told us how to set up an account with ICS. The system is inefficient and families suffer. The process of funding a prepaid phone account is extremely difficult and opaque, with hard to follow automation and no human operators readily available. To fund an account, the fees are high and they require the use of a credit or debit card, which many people of fewer means do not have. We were fortunate to be able to afford the expensive prepaid phone plan for our son. Many are not so fortunate. For example, we made multiple calls on behalf of our son's cellmate who could not otherwise reach his own family. This situation is not uncommon. Our son was incarcerated during a period of severe mental illness. While in jail, he received no medical or psychiatric treatment of any kind. He was under a lot of stress, and during our calls, he frequently broke down. His condition would have become much worse if he had not been able to get the emotional support our phone calls provided. Many people incarcerated in Maryland's prisons cannot get such support, and I urge you to make a difference in the lives of families by supporting this legislation. Thank you.
Good afternoon, Chair Clippinger and the committee. My name is Antonia Jeffrey, and I'm the Director of Policy Campaigns and Government Affairs at Worth Rises, a national nonprofit dedicated to ending the exploitation of people impacted by incarceration. Thank you for taking the time to hear testimony, and we are here in support of HB 401. We hope you will take particular note of the powerful stories of people who have been directly impacted and how the exorbitant cost of prison communication has weighed on their lives. I will focus my testimony on the policy arguments and fiscal considerations. The Worth Rises has helped jurisdictions across the country move towards providing free communications for people incarcerated and their support networks. We led the first successful state campaign in Connecticut and additional state campaigns in California, Minnesota, Massachusetts, and Colorado. We also led successful local campaigns in several major cities and are currently supporting similar legislation in over a dozen jurisdictions. Accordingly, we know what it takes to implement this policy and are committed to helping Maryland to do so. Today, Maryland families currently pay the state's prison telecom provider, Global Tellink, an estimated $12 million each year to speak to their incarcerated loved ones. This money comes from the families, including grandparents, spouses, children, siblings, and friends. They are often forced to choose between paying for their basic necessities, like housing and food, and paying to hear the voices of their incarcerated loved ones. In fact, 1 in 3 families go into debt trying to stay connected, and 87% of those who bear the burden are women. Based on our prior work, we estimate that providing these phone calls will cost the state $2.8 million per year. This accounts for new regulations passed by the FCC, which, beyond significantly lowering rates for phone calls and videos, prohibit ancillary fees, including deposit fees, and bans commissions through the pass-through of surveillance costs to incarcerated people and their families. The bottom line is that providing free communication pales in comparison to what families are paying. Studies have shown that communication will continue to increase hope, strengthen families, and mitigate trauma for children. And providing this would lift a critical burden for Maryland's families. In that, we ask that you vote yes on HB 401.
Sir?
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I'm Mark Woodard on behalf of the Job Opportunities Task Force in support of House Bill 401. The bill does 3 things. 1, it shifts the cost from incarcerated individuals and their families to the state. 2nd, it has a delayed effective date, ladies and gentlemen. It doesn't have to happen now. The effective date is July of 2026, not this year. And the 3rd thing, it has an advisory committee to make sure that in the interim, we come forward with the best, most cost-effective, most overall effective proposal so that this can be done for incarcerated individuals and their families. It can also be done at a lower cost. Worth Rises' experience is that it can probably do this for 1/3 of the cost of what it's costing the state of Maryland now. Finally, I think one of the most important points is that almost all incarcerated individuals will be coming home to the community. Family connection will help them have successful reentry, be productive citizens, be taxpayers, help the workforce, help the tax base, and help their families. We'll be spending pennies to save dollars. For these reasons, Mr. Chairman, members of the committee, we urge a favorable report on House Bill 401.
Good afternoon, committee, chairman, vice chair. My name is Terry Speaks. I'm with Out for Justice Leadership Development Organizer for the community. I was once incarcerated, and during my incarceration, my mother was on her deathbed. I didn't have funds to call home, and I was denied a phone call by the administration. So by the time I was able to reach my mother, she was passed. My only reason here today is to urge the committee to pass HB 401. So individuals in my circumstances won't have to face that same barrier. It was very hard on me not having my mother or hearing her voice before she passed away. And I kind of get choked up now because me and my mother was very close. So when I had the opportunity to come before y'all to speak on this issue, it was very dear to my heart because I know a lot of people that's inside of prison don't have money. So if you can make it a little easier, I urge y'all to pass this bill. Thank you.
Yes, this question is for Delegate Roberson. First of all, I'm really honored to be the first one to ask you a question, because as you're very fond of saying, you always remember your first. But my my question is this. You have an $8 million fiscal note in FY27. Do you have anything to rebut the assertions of the Department of Public Safety and Corrections or other data, that shows it's a much lower cost or things like that?
Yeah, thank you, Delegate Kaufman. Actually, Worth Rises has done the research on that, and I'll defer to her. But yes, I do remember my first, and I appreciate you being that on today.
You could just share that with the committee, that'd be great.
Yes, and I also say that everything that I'm going to talk about, I will share with all of the committee members and has been submitted along with my written testimony. So the fiscal analysis that was drafted by Legislative Services does not also include a lot of other things like deposit fees, taxes and other fees, and savings costs, along with the rate. So that's how Worth Rises came up with the fiscal analysis of actually being a cost savings to the state of $12 million. However, our fiscal analysis that reaches 2.8, it comes from a model that incorporates one very important thing that I want to mention, which is the power to renegotiate the contracts with the telecom provider. In every state that has passed this policy, that has been done, and it's brought rates to as low as 0.9 cents. Maryland is around 3 cents right now, so using that along with the average time that is currently used on the phones from the places that have already passed this legislation, that's how we arrived at the fiscal note of $2.8 million, and I'm happy to send the additional details and research that's in this paper.
Thank you.
Vice Chair.
Thank you, Mr. Chair, and thank you, Delegate Roberson, for bringing the bill. I have a question regarding two questions. One, have you looked into voice VoIP? And is that a cheaper cost would that be a cheaper cost to the state?
You said voice or video IP?
Yeah, voice over internet, whatever it is, VoIP, where it's an internet phone call.
Yes, there are various different models, and we actually have a fiscal analysis for each. The cheapest would be paying by line, or if tablets are fully implemented into the Maryland system, that would be the cheapest option. But it goes anywhere from about $2.8 to about $4 million on the higher end for the traditional wall units.
Okay.
So yes, the answer is yes.
So is my understanding that tablets are available now, is that correct?
Correct.
Yes, I heard some.
Yes, that's correct. Yes, ma'am.
Okay, so my third question and final question is, has there been any type of either national or state fund with respect to families having like a, I don't know, some type of fund to help each other with respect to phone calls? And I'm only suggesting that because while there are some families who cannot afford, there are some families who can afford, and sometimes pooling your resources, just in the temporary, since we do have this high fiscal note, sometimes pulling the resources can get to the goal while you're waiting on the government to take action. Is that anything that's nationally going on, or?
To answer your question, no, ma'am, I'm not aware, but we can do some research to see if there is that.
Okay, thank you. Good to see you,
You as well, thank you.
Seeing no other questions for this panel, thank you all very much. I'm going to just call the remaining names in order as I have them here. Aaron Kraus, Cam Bridges, Vanita Taylor, Michelle Coaudio, or Coaudio. And if I have room for two more, then I will call the last two people on the list, Martin Mitchell and Heather Warnken. Again, starting from my right, moving across, I'll be fine. Please, go ahead.
Good afternoon, Chair Clippinger and committee members. My name is Erin Krause. I'm a student attorney in the Youth Education and Justice Clinic at the University of Maryland Francis King Carey School of Law. Many incarcerated individuals experience isolation. Their families, especially their children, are profoundly impacted by their absence. Increasing access to telephone services allows these Maryland families to stay connected. Think about how a simple phone call from a loved one can bring hope and comfort. Incarcerated individuals need access to their support systems, and research shows maintaining familial relationships during incarceration promotes rehabilitation while reducing recidivism. The financial burdens of prison telephone services are overwhelming for incarcerated individuals and their families. Incarcerated individuals earn pennies an hour through their institution's work programs, making it impossible to afford these calls. As a result, the financial strain falls on their families. Many families are low income. They scramble to cover basic needs like food and rent. For some families, it is extraordinarily difficult and for others impossible to spare any of their hard-earned limited income on these telephone calls. Passing House Bill 401 would relieve this financial burden from families. It would also promote racial and economic equity across the state. House Bill 401 is about connecting and strengthening Maryland families. This bill promotes rehabilitation, reduces recidivism, and as a result, ultimately lowers the exorbitant cost of incarceration borne by taxpayers. For these reasons, the clinic strongly supports House Bill 401 and respectfully requests a favorable report. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. My name is Cam Bridges, and I'm a public policy advocate for Job Opportunities Task Force, a nonprofit organization that helps low-income workers gain access to higher-paying jobs. Almost all incarcerated individuals will be released back into the community at some point. Consequently, the community, taxpayers, DPSCS, the legislature, and of course the inmates themselves have a vested interest in their successful reentry. A study showed that one of the major self-reported reasons formerly incarcerated people return to prison is when they're released, they return oftentimes to an unfamiliar world and lack relationships with people who can help them navigate it. Making phone calls free for incarcerated people will help them maintain connections with a much-needed support system outside the wall. This is a public safety benefit for the community as a whole because it will decrease the number of individuals that ultimately reoffend. In addition, the state of Maryland spends between $50,000 and $60,000 annually on overhead per incarcerated individual. With Worth Rise's fiscal analysis that this legislation could be implemented for $2.8 million if only 54 less individuals return to prison each year. This legislation will ultimately pay for itself on the back end. JOTF appreciates the opportunity to testify and encourages the committee to vote favorably on House Bill 401. Thank you.
Good afternoon, Chairman Clippinger and members of the Judiciary. We are here to say we are in support of this bill because it is about public safety. Oh, Fanita Taylor from the Public Defender's Office. I forgot to tell you who I was today. Oh, okay. Yes, Fanita Taylor from the Office of the Public Defender. We're in support of this bill because it makes sense. It connects our individuals, our community that is behind the walls with the community that is outside of the walls, their families. Their families who can least likely afford these telephone calls. A large number of my clients, their families outside can't afford collect calls. And the ones that can rely upon government phones, which are minute phones. If anybody remembers minute phones, the government phones are minute phones. And when your minutes are up, you're up. With this bill, there is a task force. And the task force, its goal is to seek out what ways could Maryland do better. They're not going to do better unless we all say, you must do better. The task force job is not just to look to see, what can we do, what's going on across the state, but also to find things that are better. We all know now we have Google Voice, which is free. We know there's WhatsApp, which is free. Why are we not in the state of Maryland in the 21st century? Why don't we have access to that technology for our folks who are behind the walls? We can do better, and we should. And if we have a task force, we have someone who's particularly looking at the issue and looking at the cost factors and saying, yes, this is what's available. Technology is ever improving every day. And in fact, on top of that, I would just like to conclude by saying that this bill is not to be implemented until 2026. So there is time for us to get our ducks in orders and get our fiscal house in order to be able to do this, to service our community as well as the employees that work in the Department of Corrections.
Greetings, Chair and distinguished members of the committee. I appreciate you for taking up this issue. My name is Martin Mitchell. I'm a former at-large councilman for the city of Laurel and an active NAACP member. But today I'm here as a community organizer with Life After Release. Life After Release is a community-based reentry organization that helps our brothers and sisters returning home, and some while still in a carceral state. Many times we do not truly understand an issue or empathize with an issue until it affects us personally. This bill is personal to me because I have a younger cousin who has been incarcerated for several years, but fortunately will be released this June. One of the things that has always bothered me was the irregularity of our phone calls, mainly because of the high cost of those phone calls while incarcerated. The greedy correctional telecommunications vendors and their complicit government partners are exploiting families. I don't know if any of you guys have ever been on one of those phone calls, but it's almost anxiety-inducing when you're 1 minute left, and so you're trying to like shove everything you can remember into 1 minute of a conversation to somebody who you barely communicate with in the first place. So this bill is really personal to me, and I think that, of course, you know, it's going to come to a decision of where do we come for the, where does the money come from? But if it means enough for us to connect these families, we will find the money to connect these families and make these individuals and families whole, because that's what's important, making sure that these individuals and these families are whole. And so I implore this deliberative body to affirmatively pass Connected Families HB401. Thank you.
Hi, sorry I have to wear these sunglasses. They're prescriptive and I can't find the others. But thank you all for listening and being here. I'm Michelle Kennedy Quadio and I support House Bill 401. I'm a Montgomery County homeowner and I vote. I advocate for bills that lead to prison and justice reform, and I work with a diverse network of dedicated people in various organizations, including the Maryland Alliance for Justice Reform and Maryland Cure. I ask for your favorable support on this bill because the phone is a lifeline to my son and many other people in prison. As a retired senior, I pay about $25 a month for phone communication with my son, and he pays another $35 out of the commissary funds I send him to connect with other family members. He earns only $20 a month for 160 hours work in prison. I also send $300 a month for commissary needs. These costs are increasingly untenable for me and for many other families, roughly 15,000, by the way. Affordability of telephone communication, whether prison-issued tablets or phones in a common area, through reduced fees and lower competitive rates will help nearly 15,000 Maryland families stay connected. This is particularly crucial when there are routine cell lockdowns due to persistent staff shortages and access to phones in common area is unavailable. Phone calls on the tablets have helped me and other family members stay connected, particularly when our loved ones are experiencing medical, psychiatric, or dental emergencies and without appropriate prison response. Finally, lower rates to Maryland prisons and no-cost calls to people in prison and their families can serve as an effective means to stay in touch and as a viable alternative to reduced in-person weekend visits, often difficult for elderly and young family members or family members that must work weekends to support the family. With reduced in-person visits, less staff may be required. Please support this bill and thank you for your time.
A couple of questions, and one, this is probably to OPD. And thank you all for coming, and thank you to the delegate for bringing this bill again. Everybody's concerned about a fiscal note. Are we aware of how the tablets are used today for communication outside of the walls? So it's my understanding I don't think that you can use voice, but I can communicate through messaging using tablets today. Is anyone aware?
I'm aware. My son's been at ECI for 8 years, and so through the tablet, we can talk on the phone or you can text message, which keeps that communication seamless. And as I've said, over the last few years where there's been significantly cell lockdowns, where they can't get to the common area where the phones are, these tablets become essential, both in the voice communication and the tablet messaging. Thank you.
So do we still need a traditional phone system in your experience?
Yes, and the reason is because sometimes nothing is seamless. If there's an internet failure, we still need that phone as a backup. So they both back each other up. But I would say that my experience and that of other families is with the communication through the tablets, if there's a lockdown and there's a medical emergency and for whatever reason staff is not responding, this has been the lifeline. So I think we need both.
And this really may be for OPD because it's kind of a legal issue. The state's attorneys have indicated that whatever we do, they don't disagree with increasing access to family members, but they talk about the ability to be able to sometimes, I guess, listen in on conversations if appropriate. I think that's what they say.
Most phone calls, except for legal phone calls, are all recorded, whether they're on the tablet or whether on the traditional hand phone units that we used to be used to. Now everybody has cell phone. I don't know how many people, even here, have landlines in their house anymore.
So they are able to record the tablet calls? I wasn't aware of that. I knew they could do the landline.
They record all calls.
Okay.
All calls are recorded. And technology is changing every day, so who knows what will be available next year when this bill will be implemented in 2026.
Okay. Thank you.
All right, seeing no further questions for this panel, we thank you all very much. Seeing no one else to testify on this bill, that concludes the testimony on House Bill 401. We're going now to House Bill 445 and Delegate Hill. There she is. All right. If you would like to call up Sarah Sample and Robert Phillips, please. It'll be 3 minutes for Delegate Hill, 2 minutes for everyone else. Delegate Hill, whenever you're ready, go ahead.
Good, and thank you. And there are two bills here, 445, which you called, and 444, and they're similar. Mr. Chair, Madam Vice Chair, 445, criminal law, public safety, interference with public safety, answering point penalties. I'm Delegate Terry Hill. This is a bill that I have presented to this committee the last 2 years, and this committee, in its wisdom, has voted out the last 2 years. In fact, this committee was so wise that those 2 years, the bill was voted off the floor by without opposition, landed in JPR, made it to the voting list, but never came to a vote. So we are presenting the bill, and I can make a case for it if you would like, Mr. Chair, but I think you all have heard it. And it's in the written documents, and I've got witnesses here who can speak to the importance of it, and we're certainly here for questions.
All right, does anybody have any questions? Is this for either bill or just for 445?
Together, or we can find out.
All right, well, let's start with this. Does anybody have any questions related to 445? Seeing none, thank you for that. Now we'll go, would the two of you like to speak on House Bill 445? If so, go ahead.
Thank you, Chair, members of the committee, for having me today. My name is Sarah Sample. I'm here from the Maryland Association of Counties, and we are here to support this bill as well as Bill 444. This is a good governance bill. We don't typically show up to weigh in on something that has to do with penalties unless it is something that is really significant in terms of fiscal or operational impact. These are the types of attacks that are increasing in frequency, severity, and cost, and the consequences are staggering and can sometimes be life-threatening. These are the systems that we use to keep our residents safe, and we need to be able to rely on those and protect those, particularly as these attacks are getting way more sophisticated than they used to be. So this is absolutely something that we would support. So we are urging a favorable report. Thank you.
Yes, Mr. Chair, committees. My name is Chief Robert Phillips. I am a past fire chief out of the city of Cambridge. I'm presently the legislative chair for the Maryland State Firefighters Association. I'm here on behalf of the firefighters of this state and other EMS rescue responders. The answering points that we're talking about right now and the infrastructure that supports them is very important to your first responders. If a person makes a phone call in need to a public safety answering point, it's got to go through this infrastructure. It's got to go to the people that work there. They've got to gather the information and get it to the first responders. If there's a breakdown anywhere, it can be a catastrophic breakdown with some very serious consequences due to the fact that it didn't go through or it was interrupted while it was going through. The MSFA and the Fire Service, EMS and Rescue Service do sponsor both of these bills. We support them, and we hope that you will return a favorable vote.
Seeing none, thank you for that. So that would conclude the testimony on House Bill 445. It's 444 now. If you'd like to go ahead with that,
Thank you very much.
We'll
Again,
take all three of you for 445.
Again, for the record, Terry Hill presenting House Bill 444, Criminal Law, Public Safety, Interference with Critical Infrastructure or Public Safety Answering Penalties. This bill is really an expansion of 445, which, as I previously testified, this committee in its wisdom has voted out, and the House in its wisdom has voted out for 2 years in a row. The previous bill really talks about public service answering points, 911 centers. This bill says that the same protections that we're offering there really need to go to all of our critical cyber infrastructure. I think most of the folks here, if not everyone in the room, is very much aware of the cyber attacks that have become increasingly frequent, whether they're attacks on hospitals, the Maryland Department of Health, Baltimore City, Baltimore County Schools, and even the Colonial Pipeline ransomware attack. And frankly, the penalties that we have here in Maryland are woefully insufficient. And so this bill takes 445 and includes, it expands by creating the definition of critical infrastructure for all of those systems. National Cyber aims to deter future bad actors and improve accountability. It broadens the type of digital systems subject to penalties beyond 911 systems. Critical infrastructure is defined as both physical and virtual systems and assets that are vital to the state, a county, or municipality, for which incapacitation or destruction of one or more components would have a debilitating impact on public security, economic security, public health, or public safety. It explicitly targets the modern cyber threats that we are so familiar with, ransomware, denial of service attacks, and it creates a felony with clear enforceable penalties of up to 5 years and up to $25,000 or both for actions that are carried out with the intention of disabling the systems. And those penalties are up to 10 years and up to $50,000 for actions that are successful in disabling those penalties. The work group that formed in 2022, including members of this committee, came up with these specific penalty recommendations by looking at the laws around related statute and finding where it fits. And I strongly suggest that you either pass this bill instead of 445 because it would be inclusive, or pass them both if in your wisdom it's important that both be taken care of. And then I would ask that the chair use his great heft to lean on the much more slight chair on the other side.
Testimony is the same on this. We would like to see this bill passed or both bills. Thank you.
Thank you very much. Yes, we are in full support of both of these bills. Thank you.
Are there any questions? Not about my heft. All right. Seeing none, thank you very much.
And it's a
thank you. Thank you. Well, fortunately, this bill is over, and we're going to move on to the Vice Chair. Thank you very much, Delegate Hill. We'll go to the Vice Chair now with House Bill 392. And if you'd like to call up anyone who would be part of your first panel, that would be fine. Is Vicki Schultz here too? That's your sixth, right? Yeah, why don't we go ahead, we'll let Vicki camp out there at the end and we'll figure it out. Somebody will camp out there at the end, but Madam Vice Chair, 3 minutes, everybody else gets 2.
Great. Thank you, Mr. Chair, and thank you, members of the wonderful House Judiciary Committee. For the record, I'm Sandy Bartlett, representing Anne Arundel County, and I have the honor and pleasure of introducing House Bill 392, which is a priority of the Legislative Black Caucus of Maryland and also supported by the Latino Caucus. This bill pertains to the submission of audio recording evidence in fair housing testing cases. Currently, Maryland's fair housing testers may not make an audio recording of an interaction with the landlord or seller because Maryland law obviously requires two-party consent. We've talked about that before. Let me just give you a quick history lesson. The Fair Housing Act of 1968 prohibited housing discrimination, prohibited and prohibits housing discrimination, and came as a follow-up to the Civil Rights Act of 1964. The Fair Housing Act of 1968 prohibits discrimination in housing because of race, color, national origin, religion, sex, including gender identity and sexual orientation, disability, or familial status. HUD, the Office of Housing and Urban Development, provides a nice history of the act and how it came about. You might want to check it out. Congress passed the Act of 1968 in the wake of the assassination of Dr. Martin Luther King and the Vietnam War. There were young, poor African Americans and Hispanic infantrymen coming home from Vietnam to find discrimination, and they could not purchase or rent homes. The Act of 1968 sought to reduce discrimination against people seeking to satisfy their basic need of having a place to live. This legislation, House Bill 392, is necessary because fair housing testers play an integral role in ensuring that Marylanders have a fair and equitable housing market. Currently, fair housing testers in Maryland handwrite their notes during and after a fair housing test. Not only is this process outdated and not the best evidence, it limits the ability to capture the entire potentially discriminatory nature of the communication. House Bill 392 exempts fair housing testers from the two-party consent rule. The admission portion of the recorded communication must be relevant to the enforcement of federal, state, or local fair housing laws. In closing, I want to emphasize that this body will hear another bill to create an exception to the two-party consent requirement in cases of domestic violence. I am a co-sponsor of that bill, and I strongly believe and urge the committee to pass both bills because we should protect the discriminated as well as the abused. A government is only as strong as the protections we put in place for our residents. Thank you, Mr. Chair.
Mr. Chair. Mr. Chair, members of the committee, I'm Jonathan Smith. I'm Chief of the Civil Rights Division of the Office of the Maryland Attorney General. Housing discrimination is a serious problem in the state of Maryland. HB 392 will allow a very limited exception to the two-party consent requirement to record a conversation for the purposes of testing in aid of the enforcement of our fair housing laws. In many cases, the recording of a fair housing test will be the best evidence admissible in court that discrimination is occurring and will facilitate effective remediation. On behalf of the Civil Rights Division of the Office of the Maryland Attorney General, I offer support for this bill. Marylanders are protected in housing by state, local, and federal law. Effective enforcement is absolutely necessary to ensure that these laws are meaningful. For more than 40 years, the courts have allowed testing for fair housing cases. Testing involves the use of a trained individual who applies for housing to determine whether there is discrimination. Often this involves matched pairs, persons who are similarly situated except for the tested demographic characteristic, to measure whether they receive the same information or opportunity. Discrimination has become more subtle. Without testing, an applicant or a prospective purchaser does not know that they're being treated differently than others who do not share that demographic characteristic. It is also important to note that HB 392 does not permit wiretapping or the recording of calls for which the tester is not a party. The bill only allows recording if the tester is a party to the call and only for fair housing testing and for no other purpose. Testing can be performed without a recording, as we've heard. However, with a recording, the judge or the jury can hear directly what was said, conflicts in testimony can be resolved, and lapses in memory avoided. It is the best evidence it is the best evidence making enforcement more effective and protecting landlords from misunderstanding or mistaken memories. For those reasons, we urge a favorable report. I almost made it in 2 minutes.
Okay, the challenge is on. My name is Vicki Schultz. I'm Executive Director of Maryland Legal Aid. We are the largest provider of civil legal services in Maryland for low-income and vulnerable Marylanders. And our housing practice is our largest practice among our work. We work in the eviction prevention and foreclosure defense space to try and make sure that people have access to safe and affordable housing. And as we know, we have a challenge here in Maryland with affordable housing and housing stability, and one of those challenges involves illegal discrimination. We have a legacy of discrimination, and regrettably, that discrimination still occurs. However, it's not enough to believe or suspect discrimination. We have to be able to prove it in court. And as my colleague just stated and went through, he took many of the things I was going to talk about, it's nearly impossible to be able to prove for an individual to prove that there has been discrimination when they are turned away and told there is no housing available, or that they cannot get that mortgage or that appraisal. They don't know that they're being treated differently. It's absolutely critical to be able to have third-party independent testers who can, in fact, prove that in court. I was once in the Civil Rights Division as a Deputy Assistant Attorney General, overseeing the enforcement of our fair housing and fair lending laws for the Justice Department. And as part of that, fair housing testing was a critical tool to be able to investigate suspected discrimination. This is not a gotcha exercise. This really involves credible evidence. If someone is engaged in illegal discriminatory conduct, fair housing testing will root that out. If they are not, they have nothing to worry about. This is really about getting to the heart of bad actors in our housing market here in Maryland. So at a time where we are concerned about the enforcement of civil rights laws at the federal level, it is all the more important for our state to adopt this critical tool, and we urge passage of the bill. Thank you.
Good afternoon, Mr. Chair and members of the committee. Thank you for your time this afternoon. My name is Stephanie Murdoch, and I'm the Director of Legislative Services for Baltimore City Department of Housing and Community Development, testifying in support of this bill. Baltimore City supports affirmatively furthering fair housing in a number of ways. Baltimore City chairs the Regional Fair Housing Group, which is a forum where local governments and public housing authorities can carry out coordinated planning and implementation related to their duty. Recently, the group worked with the Baltimore Metropolitan Council to create a new 2025 regional analysis of impediments to fair housing choice, analyzing fair housing-related disparities and opportunity and creating action plans to address them over the next coming 5 years. This legislation aligns with the efforts of the group. Baltimore City also funds fair housing testing through community development block grants. We recently entered into a 6-month contract with the nonprofit organization Equal Rights Center to conduct 52 fair housing tests, which will include both phone and in-person testing, to assess housing providers' compliance with existing law on the basis of race, source of income, disability, familial status, and accessible design and construction. One of the best ways to stop housing discrimination is conducting fair housing testing, but it can be hard to enforce if you don't have the right tools. While fair housing testers diligently endeavor to take accurate notes during a housing interaction, written records can be challenged or denied by bad actors. Testers across the nation rely on audio recordings as key evidence in their investigations. Furthermore, best practices dictate that testers record their interactions. It cannot be understated how impactful audio recordings can be when proving housing discrimination. Audio recordings provide direct evidence of a violation and can even further enforcement by compelling bad actors to correct their behaviors. For those reasons, the Baltimore City Administration supports this bill. Thank you.
Good afternoon, Chairperson Clippinger and members of the committee. My name is Cleveland Horton. I serve as the Executive Director for the Maryland Commission on Civil Rights. But I come before you today not just as the Executive Director of the Maryland Commission on Civil Rights, but as a relentless advocate for justice, fairness, and the protection of civil liberties for all Marylanders. I come in strong support of House Bill 392 because at its core, this legislation is about accountability, transparency, and ensuring that the voices of those who seek justice are not just heard, but protected. For far too long, individuals who have faced discrimination, harassment, and violations of their fundamental rights have encountered barriers when seeking recourse. The ability to document and preserve evidence of wrongdoing is not a luxury, it is a necessity. When victims of injustice are silenced, when their words are dismissed as mere allegations without proof, we all fail them. This bill empowers individuals by allowing fair housing testers to safely and legally record conversations in which they are a party, conversations that, in many cases, hold the key to exposing discrimination, retaliation, and the abuse of power. But let me be clear, this is not about invading privacy. This is about ensuring that truth has a voice. This is about recognizing that in too many cases, the difference between justice and injustice comes down to whether or not there is credible evidence. House Bill 392 is a necessary step in the fight for civil rights. It aligns with our duty to protect the vulnerable, to give weight to the words of those who have been harmed, and to hold accountable those who would exploit their power. This is about equity. This is about fairness. And this is about ensuring that every person in Maryland, regardless of their background, has the tools they need to advocate for themselves and their rights. The Maryland Commission on Civil Rights stands in unwavering support of this bill because we know what is at stake. We see the cases, we hear the voices, and today we urge the body to take decisive action to pass House Bill 392. For these reasons, the Maryland Commission on Civil Rights urges a favorable vote on House Bill 392.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm Executive Director of Economic Action Maryland Fund. Economic Action advances economic rights, equity, and housing justice through research, education, advocacy, and direct service. Our direct service programs touch every county in Maryland. We're here in strong support of House Bill 392 and thank the Vice Chair for sponsoring it. My colleagues have covered a lot of the key issues, so I'll just make a few brief points. The issue before the committee is a simple one. We know that housing discrimination exists in Maryland today, particularly source of income discrimination and reasonable accommodations. And if we are serious about rooting out housing discrimination, then we urge the committee to pass HB 392 and give fair housing organizations the best tools to document discrimination. I want to touch on a couple of the things that you may hear from the opposition. First, this does not undermine privacy protections. Courts have consistently found there's no reasonable expectation of privacy when a tester participates in an application process that is open to the members of the public. Secondly, you may hear there's a risk of abuse and overreach. In fact, it's the opposite. This bill provides clear guidance. It does not permit recording of calls to which the tester is not a party, and it's only for the purpose of fair housing testing. You may also hear that there is overreach. In fact, this provides better protection for both testers and property management. By recording, you can ensure that testers are operating in the way they're trained to and that they're asking the appropriate questions, and it is the best evidence for courts as well. You may hear that there's a chilling effect on communication, but again, to the contrary, when you can show recorded evidence of fair housing discrimination, this can facilitate early resolution and settlement rather than protracted litigation. We believe that this is an important tool. We want us to join all the other states that have done this, and we urge a favorable report on House Bill 392.
Thank you, Mr. Chair, and thank you, delegate and panel. I just have a logistics question for you, just trying to understand. When it was mentioned about the outdated practice of taking notes, is it the process of if someone were to take notes and then they transfer it to a form or several forms to capture what was discussed? Or is that one practice you just totally want to do away with and just maybe all electronic? I'm just trying to understand the logistics of what's being done and how that changes.
I think we would encourage both. Actually, it's a both and. It's important to take contemporaneous notes. I think every tester probably is doing that at the same time. But it's important for the trier of fact, the judge or whoever's hearing the case, that they can hear direct evidence. And so that's why the recording itself allows the person assessing the credibility to be able to hear directly what's been said. And that's why the recordings are considered the best approach.
So are there forms that have specific questions on there for you to, because I'm gonna be honest with you, I'm sitting here taking notes still. I have my laptop. I could go old school or I could go new school, whatever you want to call it. But I'm just trying to understand how that takes place just for day-to-day operational purposes.
Just to add on to what Vicky said, the fair housing testing programs are highly, HUD has developed a whole curriculum for fair housing testers and certifying fair housing testers that require that there be a supervisor of the test, that there be specific training for the testers, so that there be specific protocols about, and I've done a bunch of these cases where the lawyers will review the protocol before the testers even go out, so that the same questions are being asked, that when you do a matched pair, that they're truly a matched pair for the purposes of the law and what have you. So there's a rigid, rigorous process by which people are trained, and then how these are executed and how they're overseen when tests are being done. I agree as well that the very best evidence, what you're going to submit in court, is going to be that recording, what was said between those two human beings when they were talking. That said, all of the things that led up to the recording and everything that happened after the recording will probably be the subject of testimony by the individual, and they will be trained to how to record that information. It may be their notes. They may keep their own notes. There may be a case management system at the fair housing provider. There may be some specific form. So that the fair housing program will be the preserver of that evidence. And these are not just individuals who go out doing it. I couldn't just go out and do a test, right? I would need to be part of a fair housing program where there had been training and an established protocol, and that we had a method of preserving the evidence, both the recorded evidence, but also the evidence that would be the testimonial evidence of the individual.
Okay.
Yeah,
it helps. It helps
Okay.
to get a better
Yeah.
picture of what the process, I should say. Okay, thank you. Thank you, Mr. Chair.
Yes, I just have one question for Vice Chair Bartlett. Madam Vice Chair, I wanted to give you a chance to respond to AOBA's testimony in terms of one argument they make that your other witnesses have not touched on, and that is they must have spent some time in this committee because they pose a hypothetical. And they say that it's a slippery slope because of the fact, the example they give is, so should patients be able to record their doctors to bolster their malpractice claims? So I just wanted to give you an opportunity to address their concerns about a slippery slope.
Thank you, Delegate, and I appreciate the question. Quite frankly, I'm going to object on relevance. Because it's just really not relevant in this case. We are talking about fair housing. We're talking about discrimination. We understand what the law already is, and the law is that we cannot record your doctor unless you let that doctor know that you are recording. So we're talking, that's kind of an apples to oranges type of conversation, comparison there. But I appreciate the chance to answer that question. I did get a chance to meet with them yesterday, and I got a chance to hear their opposition. I think philosophically we agree on the premise that discrimination is bad. And so I'm going to take it from there, that discrimination is bad. As a government, we are supposed to do all that we can do to eradicate. So that's where I am on that.
And if it's okay, Mr. Chair, one more. For the lady from Legal Aid, if I could ask a question. I am a member of the disability community, and housing discrimination is still a major issue. So do you think a potential positive impact of this legislation would be that more landlords end up renting or stopping deceptive practices to wheelchair users and things of that nature?
Absolutely. We do believe this is a proven method of helping to prove discrimination. It's used throughout the country, it's used at the federal level, and it is a way to be able to identify discriminatory and illegal conduct. So we believe it helps people with disabilities, along with those in other protected classes who should enjoy the protection of the law. So yes, we think this is a way to ensure that Maryland has a fair housing market, and that is open to all regardless of their situation, and to make sure that we are not engaged in illegal discriminatory conduct in our state. So we think this will be a benefit to all.
Thank you, Mr. Chair.
Delegate Phillips.
Thank you, Mr. Chair, and thank you, Madam Vice Chair. I really struggled with this last year with Senator Sidnor because of the two-party consent state and the state that we're in. Should we be looking at this not just for housing, but for other public safety related or discriminatory related or personal health and safety related matters? And what is the difference specifically with housing versus an individual who is being abused, who may do it, or an individual, just philosophically, I guess I'm just having a challenge. Should we look at this as a whole and figure out specific exceptions, or do we just focus, I know for you, this is your bill, to just focus on housing, but philosophically, I'm challenged with that.
Yeah, so 39 other states, I believe, have implemented this type of program with respect to two-party being able to record. Maryland has not done so. I appreciate the question, but here's the situation in Maryland, in my opinion. Sometimes we have an all or nothing type of mentality in this body. I am not of the mindset of all or nothing. If you know me, you know that I am most often willing to compromise and negotiate because I believe getting something is better than having nothing at all. In this case, I don't want to hold out and continue the practice of testers having to run back to their car or whatever to take notes when we have evidence that could easily be obtainable. And there is no constitutional or any other legal reason but for the fact that it's on the books as it stands now. There's no reason, there's no policy reason to prevent, fair housing testers from recording. Just as there is, and oh good, Delegate Conaway's not here, so I can mention the body cameras. Just as there is no, the fact that we have body cam footage, and it took some time to get there. It took some time to get there, but it has been an instrumental tool in proving whether or not there was excessive use of force, et cetera, et cetera. So it has been beneficial, and it is, in fact, a form of best evidence. And so with respect to this, and as I said in my testimony, by all means, I think we should be able to pass both bills. If there is some level of abuse, I think one should be able to record that and submit that evidence. If you're asking me personally, I'd like to get rid of two-party consent altogether in the state of Maryland, but that's not the bill that we have before us, and I do believe that sometimes in government it is better to do things incrementally, one, so that the state as a whole can get used to, understanding it, but if we want to go all the way, I'm ready to go.
So the body cam, I'm going to ask you a question. In today's world, is there a reasonable expectation of privacy if all police officers, most, have body cams? Because that's kind of the basis, right? This reasonable expectation of privacy that in Maryland you're not being recorded and you don't know it.
Right. Well, there was when it first started, folks didn't know if they were being recorded or not. And it took some time. It took some time to come to that understanding that if there's an officer, it took time for the officers to understand how to utilize this new tool, and it took time for citizens to understand how to use the tool. The expectation of privacy that you bring up, Delegate Phillips, to me, from what I've understood with respect to courts, is that there's a reasonable expectation of privacy. So if it's just me and the officer, right, then one might argue that I should have an expectation of privacy. Now we know that body cams are on immediately when you're interacting with with a suspect or another individual. So we've grown. We've made that growth. As opposed to before, it was just me. It would have been just me and the officer. Now I understand that person is recording me, and I also have the advantage of having this recording as a potential suspect. So it works both ways. I think it helps both parties when they understand that there is a recording, that the law says that you are allowed to record.
With the significant changes in technology, I witnessed an incident in Washington, D.C. I didn't witness the incident, but the aftermath of a disagreement between two parties over trespass, and the individual was wearing these new glasses. And the whole interaction was recorded. And so the question I had was, given all this technology, do we ever have a reasonable expectation when I'm interacting with someone of privacy?
Well,
just a question.
The law says we do. The law says we do, and I'd like to preserve that as long as we can. But when you are, case law has shown that when you're in certain circumstances, there is no reasonable expectation of privacy. I personally don't want to get rid of the concept that there is a reasonable expectation of privacy in case law that we have established already, because I'm not willing to go that far, but I am willing to understand that when a person is going in search of a place to live, a place to build a family, a place to call their own, that they should be able to do so without discrimination.
Thank you.
Delegate Taylor.
Thank you, Mr. Chair. And thank you, Vice Chair Bartlett. You mentioned in your opening testimony that this is a Black Caucus housing priority. I just would like to reiterate that. And also, a little confused as to who deploys a tester. What's the body that actually deploys the tester? And if you suspect that there is some discrimination based on race or disability, do you send a tester in with that characteristic? Like, how does that work?
I'm going to leave this to the experts, but I just want to say one thing. In the Black community for a long time, the way it was done was I would go in to try to get a house. I'd get denied. I'd ask someone of a different persuasion to go in, and they'd get the house. So the testing was done informally, but it was done in communities that knew that there was a level of discrimination. Now, I will defer to the experts on how it's done today.
So I think it's done in a lot of different contexts. So, and I'll tell you the two contexts in which I've done work in this area. They're very often, like the city of Baltimore has engaged a fair housing testing program to do surveillance of the housing community to see if discrimination is taking place. That's often done not to identify someone for the purposes of some sort of enforcement action, but to understand whether there's policy changes that ought to be made or what have you. It could also be done to target and identify whether there's been discrimination taking place. The way I have seen that work in cases I've worked on, you very often will do a test either for two reasons. One, you'll do widespread testing of large or multiple housing providers that might be driven by what you see in terms of advertising. It might be driven by what you see in terms of rental patterns or what have you. And then where you identify that someone has engaged in discrimination in that initial test, you'll retest to confirm that the discrimination takes place. Or you may do testing if you've got a particular complainant that comes to you and says, I was subjected to discrimination by this housing provider, and then you'll do multiple tests to confirm whether that discrimination has taken place. And so that's how it's usually done. It's either done as a surveillance tool and then you focus, or it's done based upon a complaint where someone has come in and engaged in discrimination. If I could just make two other really quick points to the AOBA point, and I apologize, is that AOBA's members are all in the District of Columbia. If the parade of horribles they're worried about existed, they wouldn't be pointing to hypotheticals. They would be pointing to actual experience in the District of Columbia. Those parade of horribles in the AOBA testimony just don't exist, and in the 39 states where this is permitted, that doesn't exist. The other thing is about expectation of privacy. The courts have found that in the commercial setting, there is no expectation of privacy. And in fact, we're collecting the evidence through testing now. The only difference between this bill and what's happening now is what's the form of that evidence. It's not whether or not we're collecting the evidence. It's whether we're collecting it through the testimony of the tester or whether we're recording it. And the recording is just a far more superior way. It's fairer for everybody because you know exactly what happened. Thank you. Sorry.
All right, seeing no other questions for this panel, thank you very much. We'll move to those who are in opposition. 3 people in opposition: Aaron Greenfield, James Johnson, and Brian Anliu. Whoever would like to start can go right ahead.
Chair and members of the committee, Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. In opposition to this bill, we really appreciate the time the Vice Chair afforded us in discussing this bill yesterday. I think it was a productive conversation. We clearly have philosophical differences. Make no mistake, this bill is unprecedented. It is creating a civil exception in the wiretap statute that doesn't currently exist. There are only criminal exceptions, to my knowledge, in the wiretap statute. So you're, for the first time, creating a civil exception targeting only housing providers. And so let me also say, I know that Vice Chair may ask this question. We did a little bit of research to find out how many actual housing violations there have been through the Maryland Civil Rights Commission. And out of 661 civil rights complaints in FY 2023, only 167 were related to housing. Those are just complaints. So it seems to amount to a bit of a fishing expedition. But who's next? Who's next? Mortgage bankers, journalists, tax professionals, employers, elected officials, what new exception are we going to create? Two-party consent laws have been long recognized as an essential safeguard for personal and business communications. In fact, in 2023, the California two-party consent law considered a similar legislation before the sponsor withdrew the bill. This practice could lead to unauthorized recordings that invade privacy and harm reputations. Moreover, this bill does not specify the qualifications or training required for fair housing testers, increasing the risk of overreach by unregulated actors. And we think there are other ways to do this, that you can collect that evidence. My time is running. For those reasons, I respectfully request an unfavorable report. Mr. Chairman, with me at my request is Jim Johnson, the former police chief of Baltimore County.
Members of the committee, let me start with the police investigations of recordings that are commenced upon citizen complaint. These citizens are subject to false statement to a police officer, or recordings are commenced upon sworn affidavit by police officers. HB 392 will allow recordings about the history with absolutely no history of violations, no complaint, no way to verify there was a complaint. You could be recording companies that haven't had a complaint in 10 years, but yet you'll go in with these recorders, incident after incident. You'll be faced with new hires, 19-year-olds. Of course they were trained. Of course they were. But you're dealing with large companies as well, with thousands of available units that change by every 10 minutes. 300 or more employees who are trying to communicate with each other what's available. Maybe it wasn't available at 9:15. Maybe it is at 10:30. Police use dedicated equipment that are capable of documenting interactions, the entire recording. These recordings are kept in secure evidence vaults with strict chain of custody requirements. This is a violation of privacy. Imagine these settings. You've got 4 leasing agents with 6 or more clients in the same room. I have an expectation of privacy. I'm talking about source of income, my children, their date of birth, what schools they go to. But this is being recorded by a tester who's picking up the entire conversation in a room. These other customers are not party to the communication. I would encourage unfavorable vote on HB 392.
Good afternoon, Chair Clippinger, Madam Vice Chair, members of the committee. Brian Anley with the Apartment and Office Building Association of Metropolitan Washington. As was mentioned previously, AOBA represents multifamily housing providers in the district, Northern Virginia, and Montgomery and Prince George's counties. I want to echo the comments that Aaron and Jim made, and I also want to touch on a few of the points that were, I guess, called out in some of our written testimony. Perhaps a better comparison for the slippery slope argument would be to fair lending practices. Should there be a 2-party consent exemption for that? Or perhaps real estate appraisals that have consistently been shown to undervalue minority-owned properties. Should there be 2-party consent exemptions for that? And so what I was suggesting at and trying to get at in my written testimony is that I think there are a lot of narrow exceptions that this body and the General Assembly is going to consider that, when taken cumulatively, could potentially create a gaping hole in our 2-party consent law. And so for that reason, we respectfully urge an unfavorable report. And just before I conclude, I would just briefly touch on, because we represent members in D.C., it is true that D.C. is a one-party consent jurisdiction, and there is fair housing testing, and I looked into this a little bit and talked to some of my counterparts there, and what we found is that it's a little bit of a mixed bag. There have been fair housing testing organizations that have, in fact, been able to prove their case without using recordings, either through electronic documentation or documenting conversations through some other means. And so while DC does allow recordings for calls or in person, that's not the only means it's being used to prove this. So again, respectfully urge an unfavorable report.
Delegate Phillips.
Thank you, gentlemen. There are approximately 12 states that still maintain two-party consent. There are 38 states that do not. And so by right, this testing could take place in those 38 states. Is that correct?
There are several states, based upon research. Wisconsin, evidence is not admissible in civil cases. Oregon, you can't record in-person conversation, only via telephone. Arkansas, consent is required if the conversation there's a legal expectation of privacy. So I would suggest that when one considers this bill, they dig a little deeper dive into each individual state.
With these communications, I'm just trying to understand, do any of you, do you represent anyone else in any of these other states that allow?
So I only represent AOBA members in Maryland. However, I have a counterpart in DC that represents AOBA members in DC. And so I've talked to him a little bit about it, but I can't, I have some knowledge. I can't speak to it as authoritatively as Maryland, for example.
Okay, all right. And I appreciate this idea. I've used the term of death by 1,000 cuts to two-party consent. However, I'm just beginning to feel like, it's too easy with technology. Everything is less than private. But anyway, that's a comment. I'm sorry.
Delegate Tomlinson?
Thank you, Mr. Chair. Questions for Mr. Greenfield. Could you expand a little bit on, you were talking a little bit about your research on the number of incidents, I think you said like 150 or something?
Yeah, so I did a little bit of research and discovered that the Maryland Commission on Civil Rights audit report issued October 2024 looked at fiscal year 2023 data, and out of 661 civil rights complaints, so that covers more than housing, right? Covers public accommodations, although the gentleman from the commission could probably correct me. It covers employment situations, health services, state contracts, that out of 661 filed in FY 2023, only 167 complaints. Now, they weren't proven to be true, or maybe they were, I don't know, but 167 of those 661 were housing-related complaints. And so I'm sort of wondering, what problem are we trying to solve here by creating such an unprecedented exception? I mean, again, we don't want housing discrimination. We want to actually have people live in our units. We want to find ways to approve people. We don't, in fact, MMHA is one of the foremost trainers on fair housing law in the state. But these numbers suggest to me that this is kind of a small problem to change such a significant statute and create a civil exception for the first time where there were only criminal exceptions in the statute.
Gotcha. Thank you.
Delegate Embry?
Thank you. I just wanted to follow up. Isn't it true, though, that complaints can be made to other entities like HUD itself or some of the groups that have talked here who are in the Fair Housing Advocacy Network? So the Maryland, the Civil Rights Commission is only one place that complaints can be lodged. Is that correct?
Yeah, I don't know that. I don't know, but I assume you're probably right. I don't know.
Thank you.
Delegate Kaufman?
Yes, I think that, thank you both. This question is for either Mr., this question is for Mr. Analu. Thank you for being here. It's nice to see you as always. Couldn't the recording actually, though, help a leasing agent? Because if a potential tenant says, oh, this leasing agent touched me inappropriately or cursed me, and it turns out to be hogwash, couldn't the recording be a benefit to the employee who's victim of a scurrilous accusation? And my second question is, I believe you, and you say your association wants to stop discrimination, but it's easy to oppose a bill. So what's your alternative? If you want to stop discrimination too, what do you propose instead of this bill?
Sure. So to the first question, Delegate, I'm not sure that this bill would apply to an instance of a leasing agent potentially touching someone or behaving otherwise inappropriately that did not involve housing discrimination. I would also, just to touch on leasing agents more broadly, we're talking about oftentimes frontline staff that is, very young. Sure, they could use some additional training at times so that they don't inadvertently discriminate against someone on the basis of income, disability, or for some other reason. But, I would just submit to you all that that shouldn't be a reason to allow two-party or to provide this exemption to two-party consent. You're just essentially entrapping very, very young, maybe inexperienced frontline staff. To the second question, I would respectfully say that perhaps additional funding or beefing up the resources that these organizations have to potentially identify these issues, the housing discrimination issues that they allege are happening.
Yeah. Just very briefly, I do believe, in case you didn't understand it, I do believe my point, though, is that the recording could vindicate a leasing agent if they are subjected to a false allegation, and why I admire your determination to have empathy for 19-year-old leasing agents, isn't it also important to have empathy for people who have been discriminated against?
Absolutely, Delegate.
But as I read the bill, just following up, it says explicitly that the evidence that is collected can only be used if it is related to a fair housing claim. It can't be brought in any other proceeding, not in a criminal proceeding or anything else. So I'm not sure if that, with respect to, yeah, that, just to sort of clarify, it can only be used for fair housing, can't be used for anything else. So I'm not sure that would work as much, but sorry to intervene like that. Delegate Sample Hughes' light was on. Are you?
Oh,
yes, go ahead. Delegate Sample Hughes.
Sure. Thank you, Mr. Chair. I'm still learning some of these issues in this committee, but I wanted to understand as it relates to the. Oh, so we're all learning. All right. With regards to the 167 complaints that you had indicated, is it broken, and I can go back and look at it later, but is it broken down as to whether or not it is a multi-dwelling unit complaint versus a home loan that someone may have not been able to get? Does it come down to that far to provide data as to what type of complaint it was?
I'd have to go back and look to confirm for you, but I can certainly send you the report, the audit, and I'll go through it as well.
Okay. And then the other part, you had mentioned that the testers that was discussed in the previous panel, you said that there isn't a program that people to go through that, is that correct?
No, there is. It's just, it's not spelled out in the bill what the qualifications are required. Mr. Johnson can speak to what is actually required to train and chain of custody issues related to this kind of evidence. I mean, this is very delicate evidence, and it's important to preserve it. And I'm not sure that, again, you're opening up this exception so someone in the civil realm can effectively capture this information when really it's only allowed in Maryland on the criminal side. And so it's a very delicate balance on how they handle the evidence. And again, Mr. Johnson can speak to that far better than I can.
Okay, so you're saying that this bill should have spelled out what would be the qualifications of someone in this space to use?
I think there needs to be very specific training and guidelines on how to treat the evidence, and training related to what it would take for any nonprofit or civil rights organization, which this bill allows, to intercept communication, that we need to put some serious guardrails in place.
Okay. All right. I understand. Thank you.
Vice Chair. Thank you, Mr. Chair, and thank you, Mr. Greenwell. So I just want to make sure that we have our numbers right. And So was that from 2023, those numbers of 167?
Yeah, it was FY 2023.
Right, and so did you happen to check for 2024?
I have not. The report that I referenced was issued in October of 2024. It was an audit report.
Would it surprise you that there's been a 50% increase since the last report of 247?
It would surprise me. Are we talking the same audit report?
Yes.
And that was issued when? Because the report I'm referencing was just issued in October.
October of 2024?
Yes, ma'am.
I think there might be some discrepancy. But it would surprise you because you weren't believing that there was a trend, an increase in discrimination?
I don't know that I have an opinion on if there's an increase or not. If the numbers suggest there are, then there are. Again, our concern is we're targeted, as we discussed with you yesterday. We feel very targeted to go after just housing providers as creating this one sole civil exception. If there are more discrimination cases then, or allegations of discrimination or proven discrimination, then we should address it. But I'm not sure this is the vehicle.
Gotcha. One quick question for the gentleman from AOBA. That you mentioned why not look at fair lending or appraisal? Would you object if we did?
I would suggest that respectfully the body take a look at perhaps a more comprehensive approach rather than just a very narrow, as Mr. Greenfield said, approach of targeting just housing providers.
Okay, thank you.
Any other questions? Seeing none, that concludes the testimony now for House Bill 392. We thank you all very much. So the next bill on the list is House Bill 301, Delegate Moon. So with Delegate Moon, we'll have Stephen Smugerjeski. Oh my God, that was bad. All right, sure. From the Montgomery County Police. So we'll hear 3 minutes from Delegate Moon, 2 minutes from the gentleman from the County Police, and we'll go from there. Thank you very much.
Thank you, Mr. Chair. Colleagues, House Bill 301 is an update to Maryland's rules on using forensic genetic genealogical DNA testing to solve crimes. You will recall some of the, if you were here for some of the legislative discussions around this technology, this was a consensus process that brought stakeholders together on both sides of the discussion to figure out a way forward for Maryland to use this technology. They ultimately settled on some rules like there had to be court authorization. It could only be used for the most serious of crimes, murder, rape, felony sex offense, or national security. And there had to be no hit on the existing state and federal criminal DNA databases. My personal interest in updating this law came into being when Montgomery County made news this interim by closing a cold case, a over 20-year-old cold case using a DNA hit that was able to narrow the tree and identify a suspect. And when I saw that our past work was potentially not crazy, I asked this guy sitting next to me to tell us more about the case and how he and his team went about solving it. And I stumbled upon some things in the law that we created that were confusing. And so here's what the bill does. It's very simple. There's a requirement in the familial DNA law that says not only do all the requirements that I met have to have been met, they have to have taken reasonable investigated leads and failed to identify the suspect. And it turns out that different counties are interpreting what that means very differently. So in Montgomery County, say, where they are using this technology to solve decades-old murders, and I don't know why we would be against that. They're not using this in active cases. A case has to go cold. And as it turns out, it might be quite some time before they get to the next rung of cases, the cold cases. So it's a slower process. They have good folks working on it, but the active cases are not using this technology. Other counties in Maryland are using this for active cases because they've interpreted the same language very differently. This requirement that there be reasonable investigative leads that fail to identify the suspect. So that's the bill in a nutshell. I'm suggesting that if we've already narrowed the use of this technology to the most serious of crimes, do we really need this last requirement? And with that, I'll go over to the detective who can add some more detail to how this is used.
All right. Good afternoon. Thank you, Delegate Moon and the committee for the opportunity to speak here today. I'm Detective Steve Smugareski with the Montgomery County Police Department. I've been serving since 2002. In September of 2018, just months after the Golden State Killer was identified through forensic genealogy, I solved my first case through forensic genealogy, dubbed as the Germantown elderly rapist case. Since then, I've emerged as a leader in the field of forensic genealogy, closing several more cases and gaining national and international notoriety. We at the Montgomery County Police Department are in favor of Delegate Moon's proposed bill of House Bill 301. We do believe that it clears up confusion in the bill in regards to reasonable investigative leads. By clearing up this confusion, it allows for less interpretation and less opportunities for unnecessary or unfair case law. This bill also allows law enforcement to test DNA for forensic genealogy purposes, the tests involving DNA for forensic genealogy in a timely manner. And it also gives a priority to this DNA that it will be done in a pristine state where it doesn't have chances of degradation, contamination, or loss of that DNA. All of this is all of the protections for public privacy still remain intact in the existing safeguards in the existing bill. Thank you.
Thank you. Thank you for your testimony, and right on time. Are there any questions? Yes, Delegate Crutchfield.
Thank you very much, Madam Chair. I just want to make sure I understand the process and procedure. This went a little over my head on this, but would you please kind of explain in day-to-day operation how this would work for you, Detective?
Sure. In Montgomery County, what we do is first we'll identify a case, then we'll check to make sure that we have DNA evidence still in that case. Then we'll sit down as a team and review that case, and then we'll bring it to a representative from our state's attorney's office, representatives from our department, and we will meet and we'll determine if this case meets all the other requirements in the bill for forensic genealogy. We also determine if there were other leads that we still need to follow out, and this is in cold cases. And such, and sometimes that stops in that portion because we have to go back and we have to review or see if there's other things that we could do right now before we go into that process. After that, after everything gets approved and we're able to step forward, we do an affidavit and we bring it to a judge in Montgomery County for approval. On that portion, then we coordinate with a private lab to send our DNA to for the testing. Now, in my experience, I've had cases that came back in 4 to 6 weeks or 6 months later by the time it comes up in the queue for testing. So that's a very long lag time when we could be right from the get-go getting our stuff there and have that data. Now, the raw data comes back from the private company, but it doesn't yet get into the databases until we say it goes in, until we say, yes, we want this uploaded into, right now, law enforcement is allowed to be in 2 different databases, Family Tree DNA and GEDmatch, because they tell their consumers that law enforcement will be searching their database, and they have an option to opt in or opt out of that process. And then from there, we get a list of persons who potentially match to match, not share. They share a certain amount of DNA with our suspect or our unidentified remains, and we build a family tree from there to those extended portions, and we determine there where we go next.
Okay. And Madam Chair, okay. And how does Delegate Moon's bill change any of that for you? Or does it just create more requirements that now allow you to filter out sooner?
Yes, it helps us to get to the process sooner. Okay. It also helps a clear-cut communication of this DNA went into CODIS and we have no hit in CODIS. This offender is unidentified, so we can start the process, but we're still going to go through all the other evaluation processes within, and make sure it qualifies in this other portions of the bill.
Okay, thank you.
If I could just clarify that last point too, one of the goals of this bill is for this law to be plain on its face what it is trying to do. And so I started asking folks around who are here for this discussion, did we mean to stop police from using this in active investigations? And I'm not sure that was an understanding we had. The frame of the cold case was there because of these famous cases popping up and making the rounds of the news, but I don't think we intended this to be only a cold case tool. The other thing I would say is the way it's phrased, reasonable investigative efforts, and then it gives examples in a definition section. This is creating a justiciable issue as to whether this investigation was reasonable. And when we're trying to solve and identify suspects, again, for the most serious of crimes, murder, rape, national security, it's just hard for me to figure out what are we balancing against here? What's the purpose of these extra hurdles? We want clarity for our law enforcement departments as to what they can and cannot do, and I don't think this language gets it right.
And may I add one more thing? DNA is very sensitive, and when you take the first process to put it in an STR format or test for STRs, and then you have the extract, and then you dry it down and let it sit for 6 months in a dried state, there's potential that there could be degradation issues later on down the road. And being able to run cases parallel while doing the STRs and the SNP testing allows for a more pristine portion of that DNA. Thank you.
Delegate Embry?
Thank you. I love this bill. I had a question about the drafting. In what you need to include in the affidavit, in 4, it says you have to show that it was there's a profile and it was put into CODIS and there was no hit, but then you also have to certify that there's no known perpetrator. I just wondered, is that necessary given number 4? Would there be a scenario where you don't have a hit, but you do know who they are and you want to use it? I just wondered why number 1 was added, that's all, given number 4.
Oh, you mean why we added the identity of the perpetrator is unknown?
Exactly, given that you already require that there has to be no hit in the
I think that's
database.
It would just for that was actually just for extra clarity.
Okay.
Yeah.
Got it.
Great, thank you. Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, and thank you, Detective. I just wanted to touch on the vendor question, where you're currently utilizing companies, or law enforcement has accounts with companies that only query whose consumers or their clients know that law enforcement can query their databases, correct? Is that what you're saying? Yes. And this bill would not change that. So if it's a company that does not inform their clients, this bill in no way changes that.
This does not change that.
Thank you. Thank you, Madam Chair.
Thank you. Seeing no further questions, that concludes the testimony for House Bill 301. Thank you. Delegate Moon. We're going to proceed to House Bill 302. Delegate Moon. We have Christian Schneider from Montgomery County Government. And by virtual testimony, we'll have Debbie Feinstein of the Montgomery County State's Attorney's Office. She's not in yet, so let's go ahead and start with those we've got here, and then we'll bring in Debbie Feinstein virtually. Delegate, whenever you're ready.
Sure. Colleagues, HB 302 is a by request bill from the Montgomery County government. It's on a topic we recently heard other testimony about. This is still related to the commissioner criminal charging process. And this is yet another example of how this process can go sideways. So the bill you heard last from Delegate Addison, HB 21, was really trying to forestall these kinds of impacts from happening to all sorts of people in Maryland. And so that's one legislative approach to the commissioner problem, the problem of ordinary folks running in and alleging criminal conduct by someone, and then suddenly charges dropping on the head of someone, and then potentially not having legal representation available to them to defend themselves. So this bill takes a different angle. There's a section of law that already creates an exception to that process where a state's attorney must review the allegations before they give rise to criminal charges. And it's for folks who are at work in their work capacity who are facing these frivolous criminal charges. So in existing law, a law enforcement officer in an emergency services, a educator are all in this heightened category where you can't just go in and on your word have criminal charges filed against someone. And so this bill would add adult protective service workers and child welfare caseworkers into that list of professions where if something happens on the job, at least a state's attorney will review it for sufficiency. I am fine with both approaches because I think this is a problem for both people at work and the general residents of the state. But again, this was brought by Montgomery County to address a very specific problem they've been having.
Good afternoon, Madam Chair Bartlett and
wait for
committee.
the light to go on. Yep, there you go.
Good afternoon, Madam Chair Bartlett and committee members, and thank you, Delegate Moon, for your support on this bill. Thank you for the opportunity for me to testify in support of HB 302. My name is Christian Schneider, and I'm a licensed clinical social worker representing Montgomery County government. As an adult protective services APS worker, I'm here today because I was falsely accused of assault by a former client. On February 24, 2023, the client went to the Commissioner's office in the District Court of Maryland for Montgomery County and filed a statement of charges. The Commissioner issued a charging document for assault in the second degree and a warrant for my arrest, knowing I was an APS worker. On March 7, 2023, I received a call from a law enforcement officer who saw red flags in the statement of charges and found it suspicious. The officer informed me that the client made allegations against me and his guardian of property, and there was a warrant out for my arrest. He investigated the matter, contacted the state's attorney's office, and helped prevent my arrest, and the charge was dropped. Though I avoided being taken into custody, the experience left me very stressed. And questioning my career in APS, knowing how easily a false statement of charges could have significant legal and social ramifications to my reputation, finances, and future. Had I been arrested in front of my coworkers or family, I would have been emotionally traumatized. I could have been handcuffed and taken to jail and suspended from employment without pay. No APS worker should be subject to this risk without proper due diligence of an investigation to unfounded charges that HB 302 seeks to address. I urge the committee to issue a favorable report on HB 302 to protect dedicated APS professionals from potential life-altering false accusations. Thank you.
Thank you. We have Debbie Feinstein available now. So Ms. Feinstein, whenever you're ready.
302 seeks to address. I urge the committee to issue a favorable report.
You're going to need to turn off your computer, Ms. Feinstein.
To protect dedicated APS
volume.
professionals from potential life-altering false accusations.
Can you turn off the live feed?
Thank you. We have Debbie Feinstein available now.
Thank you so much. I'm sorry I was in the waiting room. Good afternoon, Vice Chair.
Are you ready?
Hold on.
Can you hear me?
You're gonna need to turn off your computer.
You need to turn off. Do you have on the live feed, Ms. Feinstein?
Yep. Can you hear me now?
We can hear you now. All is well. Thank you.
Okay,
You can begin.
terrific. Sorry about that. I am not used to testifying virtually. Good afternoon, Vice Chair Bartlett. Appreciate your time this afternoon. I just want to echo what's been said by Delegate Moon and by the other proponent for this bill. I believe the case that he is referring to is one that also came to my attention, and I've had numerous conversations with the county attorney's office and also with child welfare and APS leadership about the importance of this bill. We see cases, and I've seen cases over the years that I've been chief of the Special Victims Division at the Montgomery County State's Attorney's Office, where child welfare workers and adult protective services workers are charged by their clients. They aren't happy with the outcome. To give a child welfare example, I had a case where a mother was not happy that her children had been removed and were placed in foster care, and so she made false allegations against her child welfare worker that led to criminal charges. Process-wise, the state's attorney's office review would take place regardless. We would ultimately be the ones to prosecute this case. And so our review happening before the charges go through makes sense. If it's not a meritorious claim, it avoids the pain of the charge, as was described, coming down on that worker who is a civil servant committed to really serving all of us. And if the claim is meritorious, then it gets sent through and then it's prosecuted in the ordinary course. Either way, the prosecutor's office, my office, would do that review. So there's really no loss of due process, if you will, or engagement of the process, because at the end of the day, the state's attorney's office is the office that is going to review those charges. It's just given the nature of the relationship between the APS and CPS worker and the person charging them, it oftentimes what we're seeing is that these are not meritorious claims. There have been some, but often, I'm just saying often we're not seeing that. Thank you for your time. I urge this committee's support.
Thank you. So one quick question just for clarification, Delegate Moon. So would the complaint originate still with the commissioner's office, or would still originate with the commissioner's office and then the state's attorney's office would do an overview? Okay, I see heads nodding. All righty. Thank you so much. Delegate Cardin.
Thank you, Madam Chair. Thank you, Delegate Moon, for bringing the bill and for your very, very inspiring testimony. For Ms. Feinstein, is there a reason why these particular workers are somehow special versus doing this for everybody? And we had bills last week that question this process for all people and investigations. I'm wondering, is there something statistically significant about these groups getting false allegations charged against them versus just everybody?
So where we've seen the issue come up is cases that are not required to be screened by my office prior to charging through that CCB process, that citizen-generated complaint process that I think you're referring to from the hearing last week. In those cases, there are certain charges, for cases that come through as citizen-generated. There are certain cases that get reviewed by my office and certain cases that literally just go straight through to charging. For example, certain second-degree assaults. And this would be one, if charged by a citizen, the cases that we've seen have just gone straight through. They haven't had that initial review. So that's why this is carved out. And the same with, firefighters, police officer, teachers. It's because their relationship to the public and the types of situations that they may be in, that's why they're carved out separately. And rightfully so. I mean, I've screened, over the course of my career, many cases involving educators and police officers, and there have been cases that we've sent through and there have been cases that we have not. But that extra layer of protection, giving that dynamic between particularly a CPS worker and adult protective services worker and a client of theirs who's dissatisfied with the outcome, it's giving that extra layer of protection here. And we do see these cases, and certainly the ramifications as were described by the other proponent are significant.
I mean, I love this bill. I can see other groups that should probably be added here, lots of different groups. I could see, like you said, teachers. I can see adult service workers. I can see psychologists. I'm just wondering why we're picking out these two groups versus everybody. That's all.
Sure. So teachers are included in the list currently. And I hear you with respect to psychologists and others. I guess we aren't seeing those kinds of charges as often come through. They are screened, some of them pre-charge, some of them post-charge. But this particular concern, and again, I'm familiar with the case that the proponent is testifying, that the other proponent testified about. I'm so sorry, I didn't hear his name in the hullabaloo of me signing on to YouTube, or signing on to the Zoom. But I think these are important and statistically different and sort of substantively different, because it's a client accessing a government service agency, and I can see that there's need for other, but I haven't seen those kinds of case examples come in. So that's why this, and as they do, I think certainly if there's additional protections that need to be extended, they should be.
Thank you.
Thank you.
Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate. And my question is well for Ms. Feinstein. My question relates to, and I think Delegate Cardin touched on it, is the high propensity of cases in Montgomery County. Are you seeing your colleagues all across the state also running into these type of cases with adult protective services and child welfare employees statewide, or some of the colleagues that you talk to on a regular basis?
Delegate Valentine, I think that's a great question, and I will confess that I did not poll my colleagues in other jurisdictions, but if that's something that would be helpful, as I think this committee is aware, Joyce King and I co-chair a committee through the Maryland States Attorneys Associations where we do communicate regularly with our colleagues who are in similar roles as I am, and I'm happy to send that question out and find out and get an answer back to you.
Madam Chair, the reason I ask is one of the jurisdictions that I worked in had a large volume of problem with this with correctional officers. So to back to Delegate Cardin's point, there's another classification, and I didn't know if it was county specific or if it's a larger problem. That's why I ask.
Right. I mean, again, given the incidence of it in my county, I would be surprised if other jurisdictions were not experiencing the same thing with respect to HHS and APS workers, or CPS and APS workers. It's the dynamic of that relationship, I think, that has created the issue that we're seeing and what brought this law about. But again, if you would like, I'm happy to send that question out and let you know.
The scale of the problem.
Yes.
Statewide. I would be very interested to see that, if it's available.
Sure, I'll make an inquiry. Thank you, Delegate.
Thank you.
Okay, and I've been advised by our esteemed counsel that correctional officers are included in current law. Sorry, in current law, just FYI.
Yes, they are. Thank you.
Okay. Delegate Congola.
And thank you, Vice Chair. Thank you, Delegate Moon, for bringing this piece of legislation to us, because I do feel that it is very important. I believe Delegate Cardin brought up a great point that we should see this expanded. I think that what you're looking at here is the fact that when you're working with children and adults, specific populations, those human service workers are more susceptible because of the sensitivity and nature of those cases, which is why you're specifying or singling those out. But I do agree that it should be expanded. I mean, we have human service workers that work in group homes, that work in mental health inpatient facilities, drug and alcohol inpatient facilities. So and sir, thank you for sharing your story, because I know the pain of getting that master's degree, getting the clinical supervision hours, getting the 2 years of postgraduate work and taking 2 clinical exams to become fully licensed, to sign an ethical oath, and to, put our lives on the line to treat people who are the most vulnerable and to be unjustly or unfairly accused of something. So I do feel your pain, and I thank you for sharing your story to bring this to light. And also to our Montgomery County State's Attorney, I'm glad to see that the Maryland State's Attorney Association is in support of this bill. And me being here in Anne Arundel County, I can tell you that there have been cases. I have talked to colleagues across the state of Maryland who have dealt with similar situations, not to the full extent of being arrested, but it is important that we are talking about this now, so I thank you.
And Delegate Congolo, there's a question at the end that is, isn't that so?
Isn't that so?
Isn't that so?
Isn't that so?
Very good, very good. You catch on quick. Okay, Delegate Phillips.
Welcome to Judiciary, Delegate Congolo. So my question is pretty simple, Delegate, because you brought this bill and you mentioned Delegate Addison's bill. If Delegate Addison's bill were to pass as it is, would this address the general concerns for this community, or would we still need a specialized bill of this nature? And if not, would there be some alterations to Delegate Addison's bill that might address this?
I have to double check and reread her bill because it's not so, the exact text is not so clear in my head. I think it probably covers the scenario. So again, it's, no, okay, I see shaking heads, maybe not. So like I said, I haven't read the bill. But again, as to preference, I mean, certainly if, when we do this business of adding professions into lists like this, Delegate Cardin is correct. We either get them all that year, other people coming in and saying, what about me? Or we'll get them in future years as standalone bills, people coming in and saying, what about me? I think that's inevitable, but clearly a policy decision has been made to shield some government employees who are more likely, based on experience, to be the victims of these kinds of malicious charges. So I guess it's, we can make the determination as to where that is. If it requires more than APS and CPS, then sure, I'm certainly not suggesting that we take a very narrow approach. In fact, one of my constituents was in the group that testified on the last bill. He was the blogger who got hit with criminal charges for a tweet. So, and he would clearly not be covered by the bill. So personal preference, I'd like to see us help both of these populations. But again, this is a very specific section of law that was created for exactly the scenario we're seeing here.
Vice Chair, may I respond with one additional piece of information?
Yes.
Thank you. I would just add that I believe the bill that was heard last week relates to citizen-generated complaints only. So it wouldn't cover situations where the police generated a charge against Adult Protective Services or human health, Health and Human Services worker. I'm not saying that they would, knowingly or willingly generate a false charge, but if they have probable cause and receive a certain amount of information, there could be a charge going out. Now, I'm saying that very hypothetically because I haven't seen that happen, but there is a gap between the two pieces of legislation. So I would encourage, this committee to take a close look at both and certainly support this one.
Thank you. Delegate Embry?
Just my understanding is Delegate Addison's bill, as originally proposed, applied to the issuance of the warrant versus, whereas this applies to the entire issuance of charges, although her amendments, which I haven't seen with that shielding provision, may accomplish this. But hers, this is a very rigid structure, which is great, which says the state's attorney has to review and make a recommendation or charges can be issued. Anyway. But I think
no, I mean, and so they're sort of possible branches. We could have two brains and just keep adding to the list and do a separate process, or we could mash them into one and fix it all at one time. But I do think there's a lot, we've heard a lot of testimony that there's actually some problem here we need to fix.
Well, that's what we do in judiciary. We fix all the problems. Thank you, Delegate Moon. And that concludes the testimony for House Bill 302. We're going to move on to another Delegate Moon bill. And this is House Bill 413. And we're going to call up Harold Morris, Holland Brownlee, and we've got two people who are going to testify virtually, Cherie Miller and Mitzi Wall. And also, if we have, well, do you have a panel that you want to come up, Delegate Moon? Because I've got a few names here, and if I miss somebody, Rusty Carr. Hold on, let's just, so we have Rusty Carr favorable with amendment. Have you seen those amendments?
I have not. It's probably easier for me to just do the bill.
Yep.
And then folks can say what they want about it.
Okay.
They're likely to have mixed feelings about the bill.
Okay, so let's do that, everyone. We're going to follow Delegate Moon's request, and we'll just do favorable with Delegate Moon. He'll just present the bill, and then we'll call up a few other folks.
Great, thank you so much, Madam Chair. House Bill 413 is a repeat bill. Again, if you were here last year or the year before that, you've seen this bill, you voted on this bill. Just to give you a refresher for what it does and what its purpose is, this is an update to our drug and gun penalties, trying to align them with changing times. On the drugs side, there are a few reforms that the bill contemplates. One, it repeals mandatory minimum sentences for cannabis possession. Currently in law, you can get a mandatory minimum of 20 years up to 40, but mandatory 20 for possessing large amounts of marijuana. And there's an additional mandatory 5 if you're possessing large amounts of marijuana under the volume dealer statute. I don't believe those mandatory minimums have a place in a world where we have legalized cannabis. It's not to say that these behaviors become legal. They would still come with hefty penalties in the law, but not a mandatory 20. That's more than people who commit violent offenses in this state are going to get, and it's not appropriate. The other update that this bill makes, and this is an oversight we made many years ago during the Justice Reinvestment Act, is that there is some time ago to hit these mandatory minimum sentences for crack and cocaine. It used to be that you needed 10 times as much cocaine to get the mandatory as with crack. We changed that so that they became equal. But for those people who were convicted of these long sentences with this much smaller amounts of crack, they're sort of stuck in prison, and we didn't do anything for them. So the bill gives them an opportunity to request a hearing. Lastly, Delegate Grammer had a bill to clarify the Maryland cannabis legalization laws to clarify that we did not intend people to be in criminal production if they were doing things like making brownies at home. So there's language in there to clarify that aspect. On the other side of the bill, this is an omnibus. It makes adjustments to some of our firearms laws, and it upgrades from misdemeanor to felony several categories of firearms offenses. One, knowingly possessing a firearm that you think is stolen, and plus selling, transferring a stolen firearm, possessing, manufacturing, or selling a ghost gun that we also move from a misdemeanor to a felony. Trafficking of firearms would move to a felony, and possessing a firearm with a scratched out serial number would also move to a felony. So that's the bill in a nutshell. Happy to take any questions.
Well, that's a lot. So you want us to ask you questions first as opposed to going on to favorable?
Yes,
Just
please.
straight favorable?
Sure.
Okay. All right, are there any questions? Okay, well then we're gonna go ahead and move to favorable. But perhaps there'll be questions later, Delegate Moon. Okay, so we've got Harold Morris, okay, and is Holland Brownlee here?
Yes, I want to clarify that my position is favorable with amendment.
Okay, all right. We've got Cherie Miller or Mitzi Wall on virtual?
Mitzi.
Okay, and Martin Mitchell. Martin Mitchell, would you mind coming up, Mr. Mitchell? And who's the individual, the gentleman with the red shirt? Say that again? Okay, and you're favorable with amendment. Okay, so this group, Mr. Carr, do you mind just stepping back for 1 second? And as well as Holland, if you don't mind, just so we can be clear. Delegate Moon, you could stay, you're favorable, I mean, you know. No, you're good, you're good. Okay, so what we're gonna do is we're gonna hear from Mr. Morris, and we're going to hear from Mr. Mitchell, and then we'll go to our virtual testimony of Ms. Wall, sorry. So, Mr. Morris.
Okay, thank you, Madam Chair and committee. And I want to give thanks to Delegate Moon for working on this bill for 3 sessions in a row. He put in a lot of hard work. My name is Harold J. Morris, Jr. The only part that concerns me is the mandatory minimums for nonviolent cannabis distribution. Without the mandatory minimum sentence, could still be stacked by the judge, accordingly to the individual, whether it was violent or nonviolent, first offense or more. As for now, it's a one-size-fits-all conviction. It makes no sense to have a mandatory minimum for a nonviolent cannabis only. We need to give the power to the judge, not the prosecutor, to avoid malicious prosecution and unjust sentencing. I myself believe that there should be consequences for illegal sales of cannabis over 50 pounds, but not 40 years or even 20 years without parole. Cannabis of 49 pounds is only 5 years. 5 years is enough to reform someone who sold cannabis illegal, while the state of Maryland is bringing in $1.5 billion per month in sales. With these mandatory minimums, a defendant is classified as a violent criminal, even though their crime was nonviolent. Nonviolent inmates of any nature receives 20 good days per month for good behavior. Violent inmates receives 10 good days per month. Nonviolent cannabis inmates with these mandatory minimums receives only 10 good days per month. Classification is by time, not the crime. This classification also puts these nonviolent cannabis inmates in a population with violent inmates. Most violent inmates are granted parole, while nonviolent cannabis inmates are not eligible for parole. I am the father of a nonviolent cannabis prisoner. My son and his 4 children are in the 6th year of imprisonment of the state of Maryland. It's time to bring them home. Please file a favorable report for House Bill 413. Thank you and God bless.
Are you favorable?
Just favorable.
Good evening, committee, chair, and distinguished colleagues. My name is Martin Mitchell. As I said earlier, I'm a former council member in the city of Laurel, a staunch NAACP member. But, you know, for this bill, a lot of people recognize me as the cannabis councilman. You know, so I like to call myself a thought leader in the space. I have over the years been able to interact with, you know, many parents that are dealing with this situation, whether their son be charged with conspiracy to distribute. And, you know, a lot of times what I say is, you know, these individuals are just street pharmacists before it was legal, right? Like they continue to further the industry. They continue to develop the strands that we're using today, the OG strands, as we would say. So, you know, a lot of these people should be respected, not only the previous street pharmacists, but anybody. I know he said he believes in punishment for, you know, people acting illegally. I believe that there's room in the market for all of us. And I do know that we have a legal market, which I, you know, utilize as a medical customer, but I do realize that there's still going to be, there's still going to be things sold on the street. I do want to mention, when it comes particularly to this bill, you know, I'm a big fan of removing the mandatory minimums, especially in relation to cannabis. I can tell you that I've met a lot of individuals who have faced cannabis charges, and, you know, the ideology around cannabis has changed. It is medicine. Last year I saw it was one of the only successful things, you know, in the state, right? So that's why we're thinking about increasing taxes, of course, the budget deficit. But, you know, cannabis has changed lives. Cannabis will continue to change lives. And so us as a deliberative body, I hope that we move favorable to pass 413. Thank you very much.
Thank you. And so we're going to move on to Mitzi Wall, who's testifying virtual. And do we have Cherie Miller? No? Okay. So Ms. Wall, whenever you're ready. You're not driving, you're on a passenger, right? Okay. You need to unmute yourself.
Is that better?
Yeah, it's better. Thank you.
Hi. Hi. Good afternoon. Thank you to the chair and to the committee for allowing me to speak to you today. My name is Mitzi Wall. I am a Maryland resident and an executive board member with a nonprofit called Freedom Grow. I also volunteer extensively with the Last Prisoner Project. We currently represent over 300 federal and state nonviolent cannabis prisoners. In addition to their families, we provide support to them by way of commissary funding. We provide them books, educational literature, gift certificates for their families and anyone in their family who are in financial need. We see up close and personal the devastating consequences of what happens to families of those who are incarcerated for nonviolent cannabis crimes. The emotional, psychological, physical, and financial toll thrust upon these families is unconscionable, particularly in today's environment with cannabis being legal in 38 states. I'm here today to show support for Bill 413 with the exception of the mandatory minimums for nonviolent cannabis distribution. I urge you to give the power to the judges as opposed to some prosecutors who can be overzealous and request unjust sentences. Obviously, there should be consequences for illegally distributing cannabis, but certainly not. They should not be granted kingpin status, and because the quantities which turn out the mandatory minimum prison sentences. Excuse me. It is cruel and unjust punishment, and especially in light of the current legal aspects of cannabis in this country, which are currently topping $1.5 billion. Just last year in Maryland alone. I urge you to make common sense passage of Bill 413. Thank you very much.
Thank you. Are there any questions? I have a question for Delegate Moon. I just want to make sure I understand. I have two questions. One, and perhaps you stated this, is the bill is the same as last year?
I believe this is whatever the last third reader version.
Yep.
We voted. The Senate added trafficking as a felony.
Okay.
The last time around we did this, and this does pick up that change.
Okay, great. And with respect to the mandatory minimums, as I read the bill, it looks that we have before us, it looks like it's stating that you can depart from the mandatory minimums, and then you just have a bar that you have to meet to be able to do that? Or is it the reverse?
If we pass the bill, it would change the 20-year mandatory max 40 to a max 20, and it would change the mandatory minimum 5 on volume dealer to a maximum of 10. So it's certainly not a walk in the park on the possible sentence you could get, but it gives you a range so that you could, the facts of the case could
Right.
dictate where to land. It just pulls the minimums out.
Okay, great, thank you. All right, seeing no further questions, I'm going to ask the next panel to come up and dismiss this panel. Thank you. So we're going to go now to favorable with amendments. And so that would be Holland, Rusty Carr, Edward Kinney, Ms. Taylor from the Office of the Public Defender, Edward Kinney from the Office of the Public Defender, yes, and Mara Williamson from the State's Attorney's Office. Ah, there you are. Okay, great. So we're all here, and we may, are we? Okay. Okay, what we're going to do is just go ahead and start with you, Ms. Taylor, and then just work our way down. You have 2 minutes.
Taylor from the Public Defender's Office. I will not be having anything to say. My 2 colleagues from the Public Defender's Office have covered it. I don't think you need to hear from 3 of us.
Madam Chair, my name is Rusty Carr. I'm a resident of Mount Airy, District 4, a medical cannabis patient and a caregiver. I'm here to testify for this HB413, favorable with amendments. This is related to the solvent piece of the bill. Talked to Delegate Grammer about this. The solvent piece of the bill allows people to use up to the personal limit to process cannabis. My request for an amendment is to adjust the personal limit to allow for home growers. As a home grower, I am allowed to grow 2 plants or 4 plants. If I have a medical card, I have a medical card. As was discussed when the home grow amendment was added to HB 837, the expectation was that the average yield could be 6 to 8 ounces per plant. So if I harvest 1 plant and yield 6 to 8 ounces of flower, I have exceeded both the personal limit and the civil limit and have created a criminal offense by harvesting my cannabis. I don't think that's what you intended. My request is to ask for keep what you grow. I have added the language from HB 32 that would allow this and put that in my written testimony as a request. So if you review that and allow that, then home growers would be allowed to keep all of what we grow and process all of what we grow. Thank you very much.
Good afternoon, Vice Chair Bartlett and members of the committee. My name is Mara Williamson. I'm an assistant state's attorney here in Anne Arundel County. I've been a prosecutor for 17 years, and I've spent the last 10 years focusing on felony narcotics cases. The Maryland States Attorneys Association supports HB 413 with amendments. The MSAA supports reclassifying the firearms offenses listed to felonies, including the transfer of a stolen firearm and the manufacture or sale of a firearm without a manufacturer's identification mark. We all know that ghost guns are a huge issue in our state and our communities, and this is a good step towards helping, hopefully, to help stop that problem. The provision to be considered for resentencing for people who are currently incarcerated for having 448 grams, less than 448 grams of cocaine base, AKA crack, makes sense based on the recent change in the law. However, the MSAA is opposed to relaxing the penalties associated with the trafficking of large amounts of cannabis. Trafficking a large amount of a controlled dangerous substance is a dangerous business, no matter what the substance is. The threshold for the cannabis weight count is 50 pounds. And just to give you an idea of how much that's worth, on the street, a pound of cannabis is about $1,000 to $600. So that's about $50,000 to $80,000 if it was sold by the pound. If it was sold by the ounce, it could be up to almost twice that amount. We are not talking about low-level drug dealers. We're not talking about casual users. We are talking about people who are in the business of drug dealing to make money. With respect to drug kingpin, that is a very specific charge reserved for very specific people. A drug kingpin is a drug organizer plus the weight count. That is someone who is the organizer, supervisor, financier, or manager of a drug conspiracy. This is a charge that only applies to someone at the top of a criminal organization. They're only charged by this because there's a huge investigation, oftentimes a wiretap. The drug kingpin charge is not a charge that is thrown around lightly by the State's Attorney's Office of Anne Arundel County or any other office. Thank you.
Good afternoon, Chairman and members of the committee. My name is Holly Brownlee, and I am an assistant public defender in District 3, Talbot. Oh, sorry about that.
I stole it.
Talbot County on the Eastern Shore. The Office of the Public Defender respectfully requests that the committee issue of a favorable report with amendments. Firstly, with regards to the provision regarding volatile solvents, we have a concern on the Eastern Shore. There are a number of people who don't have gas, they have propane, and so we view this as potentially affecting persons in rural areas. Propane would also be used for barbecue grills. So that's a concern. I also would like to discuss the provisions that increase classification of these firearms offenses to felonies and raise jail penalties, and we respectfully request that these provisions be removed from the bill. This bill seeks to reclassify certain non-violent gun crimes, crimes that involve purchasing, possessing, or distributing stolen firearms and manufacturing guns, and make them felonies. There are already felony-level gun crimes on the books. Those largely have to do with firearm use in crimes or firearms in the possession of someone who shouldn't have it. For example, someone with a disqualifying conviction. According to the Department of Justice, increasing severity of penalties does not deter crime. People who commit crime are often not aware of the penalties attached to their offenses. Creating more felonies only increases collateral consequences, and people who carry guns illegally are often from communities that are impoverished, underserved, over-policed, and made up of citizens who've experienced significant trauma. The reason that most commonly that people even carry guns is because they don't feel safe and want to protect themselves. We feel that reclassification of these gun crimes as felonies only creates, maintains, and perpetuates conditions that create crimes and violence. And for these reasons, we urge the committee to issue a favorable report only after amending HB413. Thank you.
Thank you. Mr. Kenny.
Thank you, committee. My name is Edward Kenny. I'm also with the Office of the Public Defender. I work in the post-conviction division. And I'm going to be talking a little bit about some of the drug provisions that we really do support. Starting with ending mandatory minimums for the volume dealer and kingpin marijuana. I think it's important for the committee to realize what this actually does. It isn't going to stop the state from charging these offenses. It's not going to stop the state from asking for long sentences. What this bill is going to do is give discretion back to judges. It's going to allow judges to consider mitigating circumstances. That's what mandatory minimums deny individuals and defendants. So our office strongly supports that provision. Our office also strongly supports allowing modifications for people who've been sentenced under the crack cocaine provision. And I think it's important for the committee to remember how we got here. Crack cocaine required only 50 grams, whereas powder cocaine required 448. This made no sense scientifically or legally. It made no sense, and it was also, let's be clear, completely racist. You all fixed this problem. Good for you. We no longer have this discrepancy. This is really a positive step. But what do you say to the person who was sentenced under the old system? The person who had only 51 grams of crack and is now serving a mandatory minimum. Allowing that person to go back before a judge and ask for a sentence reconsideration only makes sense. So for that reason, we strongly support, and I think the word moral imperative is thrown around a lot. I think this really is a moral imperative, so that part of the bill should definitely be moved forward. Thank you.
Great, thank you. Any questions? Delegate Cardin.
Thank you, Madam Chair. Just real quick, thank you all for your very compelling testimony. Ms. Williamson, you seem to get cut off, and I was waiting for, I think there was like one additional reason why you're favorable with amendment. I don't know if there was.
Sure, yes, thank you. The reason is the particular drug at the heart, in the course of a drug conspiracy. The case isn't about the particular drug. The case is about the fact that there is a large-scale criminal conspiracy occurring. And what is inherent in large-scale criminal conspiracy involving an illegal commodity? It's violence. Someone is not just charged with drug kingpin because they're walking down the street with some cannabis. It's because they are directing, organizing, and managing a large-scale drug conspiracy. And to be clear, a weight count is different than a kingpin count. A kingpin is a criminal organizer, and at the result of the investigation, the police find that amount of weight, either with that person or aggregated amongst the different people involved in that conspiracy. A weight count is a separate situation where someone is just found in a discrete situation with that amount of cannabis.
Thank you.
Okay, seeing no further questions, that ends the testimony for House Bill 413. We're going to move on to Delegate Williams' bill, House Bill 380. And to give Delegate Williams time, we're going to call up Robin Elliott. And that's all I have for the favorable panel. Is that correct?
That is correct.
Okay. So whenever you're ready, Delegate Williams, you'll have 3 minutes, House Bill 380.
All right. Good afternoon, Madam Chair and members of the best committee in the House of Delegates, the Judiciary Committee. I am Delegate Nicole Williams, and I am asking for a favorable vote on House Bill 380. So I know you guys got testimony on a lot of different things about a lot of different things. This bill is really just a really simple bill. All it's doing is just removing a criminal penalty. That's it. It's not a policy bill. It's not dictating what school systems should and shouldn't do. It's not mandating anybody to do anything or suggesting that they should do something. It's just removing a criminal penalty. The sky is not going to fall if we pass this bill. That's all that this bill does. So we're just asking for a favorable report to do this small technical fix to repeal just this little outdated criminal penalty. That's it. That's all this does. Thank you.
Thank you, Delegate. And Ms. Elliott.
Good afternoon to the best committee in the House of Delegates. Robin Elliott. I'm often in front of HGO, so please don't let them tell them I said that, but I'm here today just as myself. Back in 2020, my firm conducted research of vending machine laws for the sale of over-the-counter medication in all 50 states. I have to confess, it was a terribly boring research project. It was mostly about vending machines have to have labels so that if you lose your quarter, you know where to call to get it back. The one state that stood out as being interesting is Maryland. So Maryland, at the time, Maryland and Connecticut had the only restrictions on the sale of over-the-counter medication in the country. And Maryland had and still has the only criminal penalty for the sale of an OTC product in the country. I tried to find information on why this was. The law was so old, there are no legislative records. What I did find is the Maryland General Assembly made an exception, and it's the sale of condoms, specifically in schools that the criminal penalty is on. In the 1980s, one of your colleagues, Delegate Pauline Menace, some of you may know, put in a bill to create an exception. It was at the height of the AIDS crisis. And so that bill passed, but you all have slowly been repealing Maryland's outdated vending machine restrictions, and Delegate Williams' bill would be the last piece. And I'm happy to answer any questions about the legislative history or my research. Thank you.
Thank you. Any questions? Delegate Kaufman.
Yes, Delegate Williams. I have a question. If you look at the Catholic Conference's testimony, they expressed concerns about, well, these machines could be in preschools or they could be in kindergartens, but there's nothing in your bill as I read it that indicates that principals must buy the thing or they're required to have it, and presumably principals could still use common sense as to whether or not to buy it. But this does not force nursery schools or kindergarten classes to purchase
No,
condom vending machines or anything like that?
No, it does not. It does, like I said, it doesn't dictate one way or another how school systems should proceed. It doesn't mandate anything. It doesn't require anything. It's not even suggesting anything. So yeah, hopefully common sense will prevail.
Delegate Tomlinson.
I know Delegate Kaufman just mentioned, I don't know if it's preschool or kindergarten. Why is, I mean, I know it's in the current level. Do you know why kindergarten, nurseries are all clumped in together?
I have no idea why they were put in the original law.
Okay. Madam Chair, may I ask another question? So just to be clear, so if we do repeal this, what will be in the machines? Or what can be in machines?
I mean, I guess in theory, anything could be in the machines. I mean, this is going to be, I mean, I think education policy, we try to leave to the educators. I'm not an educator. I don't do education policy. I'm not even trying to propose that. I just try to stay in my lane and be the little attorney that I am. And so whatever, if school systems decide they want to have vending machines that dispense contraception, they can do so. It wouldn't be a crime anymore. If they say we don't want vending machines that dispense contraception, they can do so, and that wouldn't be a crime either. So I really don't have an answer to the question because it doesn't dictate anything.
Okay, thanks.
Mm-hmm.
Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate. That leaves me my question. Do you think this, and this is just an opinion, I don't know what the answer is. Do you think this would be left up to the local county boards of education or maybe at the state level of whether or not this would be permitted? Strictly an opinion. I'm trying to figure out who would regulate whether or not this did or didn't happen.
There isn't any state legislation pending that I'm aware of to adopt such policies. So I guess in theory, the local boards could make a decision one way or another.
Individually, maybe?
Yeah, individually.
Thank you.
But let me just make sure I understand. So no matter what the individual board decided, this bill merely states that if they decided in the affirmative or the negative, it wouldn't be a crime.
Correct.
Okay, just want to make sure I understand. Okay, any other questions? Seeing none, thank you. That concludes the testimony for House Bill 380. Now we're going to move to Delegate Grammer with House Bill, I'm sorry, my apologies. I forgot we have unfavorable testimony. So we have, sorry, Delegate Grammer, I know. I'm just so excited to hear your bill. So we have Jonathan Alexander and Laura Bogley, please, to come forward with testimony unfavorable with respect to House Bill 380. Thank you. Whenever you're ready.
Thank you, Madam Vice Chair, members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life. It's good to be with you again today. On behalf of my board of directors and our chapters across the state, I strongly object to this bill that would put young children at risk of injury, death, and sexual abuse. This bill would recklessly repeal the criminal prohibition on selling contraception and abortion-inducing drugs in nursery schools, elementary schools, and high school vending machines. By enacting this bill into law, the Assembly will force schools to become part of the abortion drug distribution chain using taxpayer funds. This is incremental legislation. We see this every session. Next section or the session after that, you'll see another bill that'll actually say the schools are required to implement this. The school criminal code defines sexual intercourse, the criminal code defines sexual intercourse with a child as a felony, rape. Children do not need access to contraceptive drugs in elementary schools and nursery schools, but instead need adult supervision and protection. By imposing contraceptive and abortifacient drugs on school children through vending machines, this bill would undermine the role of school health providers as mandatory providers or mandatory reporters of suspected child sexual abuse. The bill would enable educators and school personnel to evade their duty as mandatory reporters of abuse, putting children at grave risk of harm. By authorizing this bill, you would be forcing schools to be part of the distribution chain. So-called contraceptive drugs approved by the Food and Drug Administration, including the mini pill or O pill and emergency contraception pills, have known harmful side effects, including death. If girls have access to these drugs through vending machines without medical supervision, they could potentially overdose and experience serious health problems. For these reasons, we urge you to protect Maryland school children from known health risks and sexual abuse by issuing an unfavorable report and on the distribution of contraceptive drugs through elementary and secondary school vending machines. Thank you.
Thank you. Are there any questions? Seeing none? Seeing one? Seeing one? Okay, Delegate Tomlinson.
Seeing none, seeing one. All right, thank you, Madam Chair. And maybe I just need to go back and figure out, or go back to school myself. But so to your knowledge, what all will this allow to be in vending machines? Are we talking about condoms? Are we talking about birth control? Are we talking about morning after? Are we talking about abortion pills? What are we talking about, to your knowledge?
Yes, thank you, Delegate, for the question. To my knowledge, a few years ago, there was a bill enacted to repeal the criminal prohibitions on selling medications in vending machines, and the Assembly enacted that. So this would allow any over-the-counter drug to be distributed in elementary school, nursery school vending machines. The problem is that many drugs that are abortifacient are mislabeled as contraceptives. So, for example, the Food and Drug Administration just approved the O pill as an over-the-counter contraceptive. That has the same drug in it as the morning after pill in just a lower dose. So the concern we would have with that is the O pill, they would say you can take that as often as every time you have sexual intercourse, you could take that. But a child who cannot make these medical decisions on their own may not understand the contraindications. They may not understand the insert that says how they can properly use this. And so they could overdose or use this improperly. There are also contraindications with other drugs. If the child is on any other prescription medications, it can actually lessen the effectiveness of the contraceptive. So there are many issues here that would require that a child should have some type of oversight by a trusted medical provider in making these decisions about their health.
Thank you.
Thank you. Seeing no further questions, we now conclude the testimony for House Bill 380.
Thank you.
We're going to move on to Delegate Grammer's bill, House Bill 314. And Delegate Grammer, I see folks walking up. That's great. So we've got Sarah David, Scott Schellenberger, I don't see him. Laura Ruth, I see Laura Ruth. Lisa Jordan, Joyce King, I see Joyce, and Amanda Rodriguez. Don't push the button.
There we go.
Okay, so we're going to have all of you all testify. We have 8 total favorable, but we're going to have Debbie Feinstein via virtual in a minute. Oh, she's here. Okay, go ahead. Delegate, whenever you're ready.
Thank you, Madam Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 314. House Bill 314 allows intercepted communication and evidence derived from the communication to be received as evidence in limited cases. What if your family member was a victim of a horrific crime? A crime that was recorded, a crime that objectively happened, but justice would never be served because the only evidence you had was a recording. And the only purpose that recording served was to traumatize the victim over and over again. You see, Maryland is a 2-party consent state. That means you must have the permission of other parties to be recorded. This leaves any recording inadmissible as evidence. House Bill 314 attempts to fix this problem, and it does so by allowing admission of recorded communication as evidence if a court determines that the communication is offered as evidence, the communication was not made as part of a law enforcement investigation, the communication is more probative than other evidence that can be procured through reasonable efforts, and that it is in the interest of justice. In this limited case, any such communication must be provided to the adverse party sufficiently in advance of the trial. I'd like to remind the committee of a shocking statistic revealed to us last session. Approximately 6% of all rape cases are prosecuted, and approximately 1% achieve a conviction. While these terrible numbers have many root causes, a significant cause is the fact that to prove the burden of the crime requires evidence that only exists in the form of limited communication, often in the form of wiretap. We should reform this law with those victims in mind. With that, thanks for the opportunity to present House Bill 314. I'd be happy to take questions. I'd ask for a favorable.
Thank you. Lisa Jordan.
Thank you. Members of the committee, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. Thank you, Delegate Grammer, for your continued leadership on this. We are here in strong support of House Bill 314. As we've testified before, there are rape cases in Maryland where survivors have picked up their cell phone and they have recorded the rape. And it is heartbreaking to tell them that even though they have good evidence, valuable evidence, evidence a fact finder should hear, that evidence cannot be admitted, that they are not going to be able to have a jury or a judge hear about what happened. There are cases we've had, kids have those toys now where they can record people's voices. We had a case, and because Mr. Schellenberger is not here, I will tell his story, where a little child recorded his mom being beaten up, and they could not use that evidence in court. You've heard several attempts over the years of ways to solve this problem, and I will confess to you, I don't care how you do it. I like this bill. I think it's a good bill. But at the end of the day, I urge this committee to solve this problem. This is outrageous that we have tapes of people being raped, and judges and juries cannot hear this. Now, this bill, the version you have this year, it follows the hearsay rules we use in court all of the time, and the catch-all hearsay rules. It does not get rid of two-party consent. It does not touch the criminal law. And it absolutely firmly requires that this not be in furtherance of law enforcement activities. This is a good and balanced approach, and we urge this committee to report favorably on 314, but if you can't do that, solve the problem, please. Thank you.
Thank you. Committee, I'm going to ask if you all could just keep down a little bit on the volume, because it's already, one, hard to hear, and two, it's very distracting. So if you, Delegate Erican, do you mind? Just, yeah, that's the problem. That's the problem.
I'm a little deaf in one ear.
Okay, that's fine. Just hold off just a second, because I see you only got like 2 more to go. But just hold off a second. Yeah. Multitasking is fine, but okay, so let's go back. We're going to go to the next person who's going to testify. I think that's going to be whoever you are ready to go next.
Good afternoon, members of the Judiciary Committee. My name is Sarah David, and I am the Deputy State Prosecutor at the Maryland Office of the State Prosecutor. Our office is tasked with the statewide prosecution of political corruption, police misconduct, and election law violations. I'm here to answer some questions about HB 314 and talk about our support of this bill, and thank you to Delegate Grammer again for your leadership on this issue. I want to reiterate importantly that this bill does not make Maryland a one-party consent state. This bill allows recordings made on a cell phone to be admitted into evidence when certain criteria is met. Right now, a recorded statement cannot come into evidence for any reason, and this includes impeachment. It means in a corruption case, if someone recorded a police officer in an interrogation room threatening them on their own cell phone and the police report said nothing was said, the recording cannot come in. It means if a public official recorded someone threatening them or a member of their family, the recording cannot come in. It means that if a contractor records an official asking for money in exchange for being awarded a contract, the evidence cannot come in. It can only come in to prosecute somebody for the offense of wiretap. So what is this? When does this allow the evidence to come in? In an evidentiary rule that already exists, which is called the residual hearsay rule, which means that a judge is going to make a determination in each and every case with a bunch of different criteria that this is the best evidence available and that this is a material fact and that the interest of justice will be best served by this evidence. This ensures that parties can't rely on wiretap evidence. It'll still be a crime, but it allows crime victims to pursue justice and prevents the serious injustice of not being able to enter evidence of a crime that happened to you.
Whoever does not touch the button gets to go next. Okay, so Ms. Ruth, you want to go next? Okay, so Ms. Lori Ruth.
Thank you. Madam Vice Chair, members of the committee, my name is Lori Ruth. I am the Public Policy Director at the Maryland Network Against Domestic Violence, and I want to thank Delegate Grammer and also the Vice Chair for this bill. I can't stress strongly enough what Ms. Jordan has already said, which is something's got to be done. And I don't know how else to say it more clearly. In our work in the domestic violence world and in the sexual assault world, the fact that we as lawyers or advocates or people, that they have come to have to tell them, I know you have absolutely incontrovertible evidence, audio evidence of your assault, of your sexual assault, of your, second degree, first degree assault, and you can't use it, and it's also a crime that you may be charged for, is really unconscionable. And so I, like Ms. Jordan, urge you to do something. HB445 is a good bill. I think you heard us testify last week on Delegate Simpson's HB130, and Ms. Jordan and I might differ on this, but I do find it a little odd to pass this bill while keeping it a crime. So at least if it was changed from a felony to a misdemeanor under Delegate Simpson's bill and this bill, that would go a long way towards correcting this problem. And for those reasons, we urge a favorable report. Thank you.
Madam Chair, members of the committee, I'm Amanda Rodriguez. I'm the CEO of Turnaround, which is a rape crisis domestic violence center, Baltimore County and Baltimore City. We also serve human trafficking survivors. I'm also testifying as a co-chair of the Legislative Committee of the Maryland Human Trafficking Task Force. I'm going to recall some of the testimony from last week because these are real cases that Turnaround has seen in our office. So in the early hours of a morning last fall, a young child was awakened to the sounds of fighting in the room next to him. He could clearly hear screaming and what sounded like slapping noises. He had heard that sound often, and he wanted to protect his mother. So he went and grabbed his mother's phone from her purse and started to record the sounds, the threats against the mother, and the sounds of the beating. When she tried to press charges, and this is what actually happened, the recording was inadmissible in the case against her, and the law enforcement officer refused to even listen to it because he said that he could potentially charge her if she were to present it to him. Another client had a security system in her home installed to keep herself safe from an abusive partner. It recorded both video and audio. She had an active protective order against her abuser. He called her in violation of that protective order and started to threaten her. This was picked up on the security system. She was unable to produce that evidence both in a protective order hearing and then also in criminal charges against her abuser. A trafficking survivor was raped while unconscious in a local hotel. She knew something was not right when the buyer came in and started to record what was happening in the room. It captured an audio of a violent rape. This is unfortunately one of the nearly dozen cases of sexual assault that Turnaround was involved in last year, that their rapes were recorded or sexual assaults were recorded, and that evidence was both not admissible, so cases could not go forward.
Rape is already one of the most underreported, underinvestigated, and underprosecuted crimes in the United States. Then telling these victims who put themselves at great peril to hit the record button that evidence that is used to bring their rapist to justice is inadmissible because of an archaic law is unconscionable. I just want to end by thanking the delegate again for bringing this bill.
No. Good afternoon, everyone. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I'm here on behalf of the Maryland State's Attorneys Association and the Special Victims Committee asking for a favorable report. This is very much just a Me Too testimony, but I do want to reiterate for the committee, as far as MSAA, I mean, this has been a top priority for the last 5 years. This year, when we met with our committee unanimously throughout every jurisdiction in the state, everybody said this was the #1 priority. And it's not just a priority for SVU victims. Obviously, that's who we represent here, but really for all victims. It's everyone's, whether you're a child or an adult, when you are afraid and something's about to happen, it's everyone's first reaction today in 2025 to take out their phone because we know it's the best evidence. And we believe it's in the best interest of justice. And thank you, Delegate Grammer, for championing this. And we do believe it's the best vehicle forward.
Great. Thank you. So we're going to move on to Ms. Feinstein next.
Thank you so much, Vice Chair Bartlett. Debbie Feinstein testifying in support of House Bill 314. I'm with the Montgomery County State's Attorney's Office. I'm testifying on behalf of my office as well as the MSAA. I want to just offer a couple of examples. In Montgomery County, an Uber driver was charged with rape. In this case, the victim had a significant amount to drink at a club and called an Uber to get her home safely, or someone called an Uber for her to get her home safely. She woke up alone in the back of the driver's car. She had no memory of what happened after she left the club, but she suspected that the offender, the driver, had had sex with her in the car. To confirm her suspicion, she asked the offender for a ride home so that she could confront him about the rape and record their conversation. During the recorded conversation, the offender admitted that the victim, was wasted and that they had had sex. The victim repeatedly accused the defendant of having sex with her while she was passed out, and he did not deny it. DNA confirmed that the offender had sex with her in the car. It could not and did not show that she was incapacitated, however. The court ruled that the recording violated the Wiretap Act and the state could not use it to cross-examine the defendant. That's correct under the current law. Moreover, the court ruled that the victim could not mention that she made a recording, not even to explain why she had asked him to take her home after believing he had raped her. The defendant testified that they had had sex, that she wasn't that drunk, and that she was not passed out, and that the victim asked if she could see him that weekend, and when he declined, the victim became offended and jealous and accused him of rape. His word against hers, and she couldn't remember the rape, just knew that it had happened. The jury acquitted, and this dangerous person is free in our community. A second brief example is an in-home daycare provider who was berating small children, forcing food down their throats and smacking them on multiple occasions. A coworker who was afraid of her recorded this activity and submitted it to be part of a case. Unfortunately, that evidence was not admissible, and the state resolved the case with a low-level plea. I urge this committee to vote in support of this bill. Thank you.
Thank you. I saw Delegate Cardin first, and then we'll move on to Delegate Pasteur.
Thank you, Madam Chair. Thank you all very much for coming in and testifying on this important bill. To the State's Attorney, Ms. Joyce, right?
King. Ms. King.
Okay. First of all, what carve-outs presently exist in the two-party consent? Are there any carve-outs at all?
So only a law enforcement exception with regards to certain crimes and certain crimes that you can record.
Okay.
It's in the fiscal note, Delegate.
What's that?
The exceptions are in the fiscal note for you to look at.
So if we pass this bill, which I hope we do, and whether we pass Delegate Simpson's bill or not, would a defense, I hope we do as well. Me too. Would a defense attorney maybe seek to have charges filed against the witness because what they're doing is illegal? Wouldn't that be the first thing the defense attorney would do?
Under the current law, a defense attorney could do that. Whether a state's attorney's office would proceed on that is an entirely different
decision.
Right, but I guess they could go to the commissioner's office and get a warrant out right now, right? Because they don't have to go through the state's attorneys at this point, like.
And Ms. David did note that we could provide immunity for those individuals.
You could provide immunity, so really the criminal charges and the reduction may not, how come that didn't come out in last week's testimony?
Because Ms. David wasn't there, but.
Okay.
Um, I think, Representative, Delegate, I think we would have to provide immunity if they were testifying as to this information. I think that we would almost have to do that. I don't think that impacts the misdemeanor versus felony. Right now, there's no way to use it, so there's nothing to give immunity for.
Right, okay.
And just so you know, these young ladies have worked really hard to get a version of Delegate Simpson's bill that's acceptable in the Senate. So maybe if you get these bills pulled into your subcommittee, we could work this all out real quick.
I'd be more than happy. I don't think that the chair would do that, but let's give it a shot.
Okay, thank you. Thank you, Delegate Grammer and panel for this. So I have a series of small, real teeny tiny questions, and you can just nod. Because as you tell your stories, they were a year ago or whatever. So I want to tell the story about 2 weeks ago, how I went to my best friend's husband's funeral. Because in 4 days, on 3 different times, her grandson attacked her husband, who was already in hospice, and his daughter. 3 times she called. One, she called the crisis center, so clearly that did not work, and they told her there was nothing they could do. Then she called the police 3 times, and they came. And the young man, the grandson, said, I don't know what's wrong with them. Clearly, I'm fine. And they left him in their house. She went to court for a protective order, which was rejected. So the next time, she recorded it. Now, that last time, at the end, I was listening to it on the phone. And I said, this is a 2-party state. You're going to have to be real careful with this. And at one point, he said to her, are you recording me? And she said no, but she recorded 37 minutes of this happening with him beating her husband, who was in hospice. Again, they called the police 2 times on that occasion, and no one came until the daughter called and said 911 and said, I will not leave. Is this not an abomination?
Yes. And if you.
Okay. And she said, I will not hang up until someone comes. The same police officer came, and she showed the officer the recording, and then they arrested him. Thank goodness for Ms. Green in Ivan Bates' office, who, when he came up last Thursday for his hearing, and she charged him with a felony. Now, will this, because I'm hearing for real that this will encompass all sorts of crimes, but the reality is this good woman could be charged at this point, all things being equal based on the law, with felony after all she's gone through, including the funeral of her husband. Again, that happened 2 days after the last event. So I'm not just saying this needs to pass. This must pass, and I'm going to end with, damn it. I know I asked a series of questions.
I have a series of brief answers for you. And if you remember, this is the 3rd iteration of this bill. When it first came through, it was brought by the folks advocating for our elderly in retirement situations. And they said we had very similar situations. We couldn't do anything. We had folks with cognitive issues. They couldn't articulate what was happening. The only way to was record that situation, but they couldn't do so. So those advocates were the first people that brought these issues to us. I think with this iteration, the third iteration of the bill, we've got away from both the two-party consent question, and we've got away from what specific crimes. So I think everybody can hear the breadth of this issue that everybody here is articulated about. I think the concern in your situation is, will that videotape recording, can that be admitted as evidence? And I don't think that it can.
Exactly.
So,
Cannot.
but I appreciate your support, Delegate.
And it is a part of the final report that my Elder Abuse Commission, they just turned in their final report. And this kind of scenario is a part of that, because otherwise it would have continued to go unwatched and not considered. But their report is really good, so it's a good thing. All of these pieces are coming up now.
Thank you.
And let's say together, isn't that so?
Isn't that so?
Yes. All right, thank you.
Very
That's so,
good.
Mr. Chair.
Very good. All righty. I don't see any other questions being presented. So that ends the favorable testimony of, with respect to House Bill 314. We have one person, Ms. Dara Johnson from ACLU, testifying unfavorable. And you may begin whenever you're ready.
Okay. Yes, thank you, Madam Chair.
Just 1 second. Okay.
Okay.
We're ready. Thank you.
Awesome. Thank you, Madam Chair and members of the committee. My name is Dara Johnson, and I am the Interim Policy Counsel for the ACLU of Maryland, here to voice our opposition to HB 314. So while there is certainly a need for adequate legal means to raise clear evidence of harm that may be captured in some audio communications, the overly broad exception proposed by this bill unfortunately lacks the safeguards needed to protect against the significant risk of severe prejudice in the almost unlimited array of cases where this could be applied. As a primary concern, this bill proposes a judicial standard that goes beyond the court's traditional role. This would have the court consider whether the communication is more probative than any other evidence the proponent can procure through reasonable efforts. While a judge's role at this stage is often focused on weighing the probative value of the evidence against the danger of unfair prejudice, this bill would allow the court to determine the actual weight of the evidence, a role typically reserved for the jury or the trier of fact at a later stage. This concern is compounded by the lack of safeguards to ensure this exception would be applied uniformly, constitutionally, and without a severe risk of prejudice. This includes, 1, the lack of any language defining the level of reasonable efforts the proponent would need to otherwise employ to procure the other evidence under the proposed admissibility standard. 2, the absence of any articulated right for the adverse party to cross-examine and question related witnesses. And 3, the failure to include any provision requiring the proponent to provide the adverse party with the identities of potential witnesses included in the communication other than the speaker. While the existing evidentiary exception for such communication only applies to those between people found to be co-conspirators in a violent offense, the broad standards proposed by this bill could apply in virtually any case. We ask that you all consider the severe risk this presents in cases that may not be so cut and dry, and urge an unfavorable report on HB 314. Thank you.
Thank you. Are there any questions? Delegate Tolles.
Thank you, Madam Vice Chair. Could you give me an example of where you feel this could be problematic and what type of situations?
So this could be problematic in situations where the harm is not so clear, where it isn't similar to the examples raised earlier today, where any of us could tell that that is occurring, where there might be a little bit more gray areas there. Then allowing that evidence to come in could present a severe risk to the defense without having the opportunity to possibly cross-examine or identify any witnesses who may also be heard in the communication.
Thank you for your answer. Can I clarify my question? Could you give me direct examples, not a general perspective, but like how Delegate Pasteur gave an example? Could you provide me an example of a situation that ACLU have seen come up in this situation, or that you would imagine would happen if this bill was to pass? An actual scenario, what they call it in law school, a hypothetical. Yes, I was like, what's that law school word? Hypothetical. Hypo. Give me a hypo.
Yes, so thank you, Delegate. So I will say that in terms of being able to provide specific information about anecdotal experiences that we have received here at the ACLU, we can definitely follow up with you to provide that information following this hearing. Because of the wide breadth of cases that this could cover, it's difficult to provide a specific example that would be something that would go beyond what I mentioned.
I asked for a hypothetical, not a specific example. Give me a hypo, make something up.
So I would say a hypothetical would be where someone is recorded in an audio saying words that one person might interpret as being words that signal abuse, while another, based on different cultural norms, based on other factors, might not see the same way. However, if that audio communication is seen as more probative than any other evidence that might be available that could possibly counter that, that could still come in, and depending on the trier effect, depending on the jury, that could then pose a severe risk of prejudice to the defense.
I mean, wouldn't the judge make that determination whether it was?
So that is also one of our concerns, right, is that at this stage, at the pretrial stage where this is coming in, those type of considerations in terms of the weight of the evidence, those typically happen later at the trial stage, either by the jury or the trial of fact, whereas here, we're allowing the court to say, we are going to actually consider whether this evidence goes towards the offense being accused, and then make that determination to allow it in or exclude it.
I think with the compelling testimony that was given on the first panel, I think it would be necessary for you to provide a little bit more expansive examples, of how you see this will be problematic.
Certainly, and we can definitely follow up with you.
Okay, because I do think that, anyway, I'll stop there. Thank you, Madam Vice Chair.
Of course, Delegate, yes.
Great, thank you very much. And thank you for the questions, everyone. That concludes the testimony for House Bill 314. Moving right along, Delegate Grammer, House Bill 374.
Thank you, Madam Chair. With your permission, I'll get started.
Okay, we also have three favorable. Would you like for them to come up? Okay, we have Gail Seaton, Linda Duncan, and that is all.
Gail is sick. She couldn't make it.
I'm sorry, I couldn't hear you.
She said Gail is sick. She can't make it.
Oh, no. Okay, I'm sorry to hear that. Linda Duncan? Okay, great. So Delegate, whenever you're ready.
Thank you, Madam Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 374. House Bill 374 removes the use of diminution credits for first-degree murder. What I want to talk about here today is an injustice that doesn't make sense. I'm joined today by Linda Duncan, whose mother was murdered. Since the time of the sentencing related to that murder, Ms. Duncan has been on a crusade to remove the use of diminution credits for murder in the state of Maryland. It doesn't make any sense. Victims of murder don't get a second chance. They never get another chance to see their loved ones. They get no chance to say goodbye. They don't get a little extra time for good behavior. They don't get a second chance at life. It doesn't make any sense. Rape and sexual abuse, these are horrible crimes. And the perpetrators of these crimes don't deserve time off for good behavior. But it's objectively worse to have your life taken. It doesn't make any sense to remove diminution credits for rape and keep them from murder. It doesn't make any sense. For the only crime that steals the life, the future of another person, to give time off for good behavior to the perpetrator. House Bill 374 fixes this injustice and ensures no time off for good behavior for murderers. Thanks for the opportunity to present House Bill 374. Be happy to take questions, and it asks for a favorable.
Ms. Duncan, whenever you're ready.
Okay. To the chair, vice chair, to the committee, thank you. Special thanks to Delegate Grammer for taking on the sponsoring and those that are co-sponsoring with him. We need to put a balance in Maryland's scale of justice for all murder victims by eliminating diminution credits used to reduce time served for the crimes of first and or second degree murder by equalizing justice for all citizens. Equal justice should not be contingent on certain racial populations, the age of the victim, or because you're a close friend of a highly ranking government official such as Wes Moore. In January of last year, 2024, LaPierre family, whose daughter Pava was raped and murdered, testified before the committee, this committee, to eliminate diminution credits for the act of first-degree rape. Within 4 months from the time it was presented, the Pava Act was signed into law by Wes Moore. And as he signed, he said, "She was my friend." I started this battle in 2015 after learning of my mom's killer's early parole due to diminution credits. And for 10 years, I've testified before this committee to pass Jerry's Law, as what it was initially called, that eliminates dim credits used to reduce the time served on heinous felony murders or second-degree murders. And you have either voted against it, or in most cases, it wasn't even presented for a vote. The only difference in the Pava Act and Jerry's Law is the act of the crime, first-degree rape versus first-degree murder. Offenders convicted of this murder of victims, 16 and younger, they don't get that offered onto their sentencing. However, if the victim is 16 years and older or over 16, the offender may use the diminution credits towards time served. This is unfair justice to the victims and their families. Offenders who commit murder can earn diminution credits, but only used within the facility of their incarceration, not towards early release. And if anyone is interested, I do have a proposal. Our family may not be close friends of Wes Moore, but he should remember that he's the governor appointed to serve all citizens in the state, and we just want the same for our mother.
Thank you, Ms. Duncan. Are there any questions? I see none. Thank you very much for your testimony. Thanks for coming in. We have 2 individuals for unfavorable panel, Edward Kinney from the Maryland Office of the Public Defender and Dara Johnson from the American Civil Liberties Union of Maryland. And whoever wants to go first is fine.
Thank you, committee. My name is Edward Kenny. I'm with the Office of the Public Defender. I am an assistant public defender with the post-conviction division. Our office's position is that we are unfavorable towards this bill, and we're unfavorable for a number of reasons. I want to talk about 2 main issues. One is I don't think this bill is going to accomplish what its proponents say it will, and I think there are going to be a number of very significant unintended consequences. Who is this bill? Let's ask the first question. Who is this bill going to affect? Well, people who've been convicted of first-degree murder. But more specifically, it's primarily going to affect people with terms of year sentences. These are people that received a life suspend all but some amount of years. Those are the people that get mandatorily released in the state of Maryland. These are people who predominantly engage in the plea process, the plea bargaining process. So this is the first question you should ask. Why are we penalizing people who predominantly engage in plea bargaining? It's a tax. The end result is going to be that less people plead guilty and more people go to trial. This is going to force victims to sit through trials of first-degree murder cases. The first thing that an attorney asks their client during the plea bargaining process is, the first question the client asks is, how long am I actually going to serve? And if you got an offer of life suspend all but 30 and you have to serve those 30 years, that's a very different answer than if you do what you're supposed to do, you could get out in 20. But this is only the beginning of the problem of the bill. The bill implicitly treats prisoners, remarkably different prisoners, equally. I represent both the prisoner who's done everything right, who's gotten their GED, who has done programming, who's reformed, as well as the prisoner who's done everything wrong. When you take away diminution credits, what you're saying is those people should be released at the same time. It undermines rehabilitation efforts in the Division of Corrections. It says, to all those people that want to do the right thing, it says, we don't care. The system exists to a certain extent to protect the client who's doing everything right from the client who isn't doing everything right. And I think we need to keep that in place. So for that reason, we ask this committee to vote unfavorable. Thank you.
Thank you. Ms. Johnson?
Again, Madam Vice Chair and members of the committee. Again, my name is Dara Johnson, and I am the Interim Policy Counsel for the ACLU of Maryland, here to voice our opposition to HB 374. I would like to start by being clear that our opposition is in no way an affirmation or dismissal of the profound harm experienced by those seeking justice surrounding the devastating circumstances of first-degree murder cases. We are simply here on behalf of the many people inside our state prisons and jails who are doing everything possible to account for these deep consequences, but would be arbitrarily foreclosed by this bill from earning credit toward full redemption in the community. As noted in a 2024 report by the Sentencing Project, recidivism rates are actually the lowest among people returning home after decades of incarceration for the most serious violent offenses. This has been continuously demonstrated by the 200 people in Maryland with such cases who were released following the Unger decision and have maintained a recidivism rate of only 3.5% for over a decade. The opportunity to earn credit toward release for positive behavior can be a huge motivator to invest in the rehabilitation that yields these statistics, while also serving as an important tool in maintaining a safe environment for those living and working inside our facilities. In 2016, this legislature passed the Juvenile Reinvestment Act, which increased the number of diminution credits one can earn out of a recognition of this tool as an undeniably effective means for achieving genuine public safety. It should be noted that this bill would also apply to those convicted of felony murder, despite only playing a potentially minor role in an underlying felony. We ask that you truly consider the cost of such blanket deprivations, the cost to our state principals against excessive punishment, the unnecessary financial costs levied by needlessly prolonged detention, and the cost to families who rely on their loved ones inside. With that in mind, the ACLU of Maryland urges an unfavorable report on HB 374.
Thank you. I have a quick question for Mr. Kinney. And I'm just looking this up really quickly. I don't have this. You probably have this at the top of your head. But my question is, with respect to first-degree murder, it's a felony, obviously. And if someone is convicted, they are facing life without the possibility of parole or life in prison. Is that imprisonment for life? Is that correct?
So first-degree murder carries a mandatory life sentence. If the state provides a notice that they're seeking life without parole, they may also seek life without parole. However, a court that is...
Oh, yeah, the mic's not on.
Okay, we're good.
Is that better?
Yes.
Sorry about that. What I was going to say is that first-degree murder carries a mandatory life sentence. If the state seeks life without parole, they may also, a judge may, in its discretion, impose life without parole. A judge may also choose to suspend a portion of the life sentence. That's allowed. And after the prisoner serves a number of years, then they're placed on probation. Does that answer your question?
Probation with the expectation of release?
So let's say you get a life suspend of about 40 years. The prisoner would serve the 40-year period, and then they'd be placed on usually 5 years of probation. If they violate their probation, then the court could impose the life sentence.
Thank you, I understand. Delegate Grammer.
Thank you, Madam Chair. Question for Mr. Kenny. So Ms. Duncan's testimony was a little bit harsh, but I gotta admit, I'd probably feel the same way if my mother was murdered. And every time we talk about these kind of issues, you know, she mentioned folks knew the governor, they get help. Other folks don't, they don't get help. We always tend to talk about people who followed the rules while incarcerated versus people who have not followed the rules while incarcerated. But you never talk about the victims. And for me, this is comparing what the victims go through to what the perpetrators go through. And you both barely even glossed over the victims who, in this case, lost their life completely. And that's why I talked about there is no second chance once you're murdered. There's no time off. Your family loses you. You don't get to say goodbye. What do you say to folks like Mrs. Duncan who don't get to have her justice served? How are they supposed to look at these cases where they've lost a family member in a horrific way and they get to watch the perpetrator walk out with good time off for bad behavior. What do we say to folks like her?
I think it's very hard. These cases are incredibly hard on victims, and I cannot begin to imagine what that witness, what was her name? I don't even. Miss Duncan. I can't even imagine what she's going through, having to live through that experience. It's incredibly difficult. And, these are serious offenses, and they deserve serious sentences, and I don't dispute that at all. The question really is, once this person is serving this sentence, are we just going to say nothing they do matters? I think there are people who really do turn their lives around in prison. And it's hard. I know it's hard on the victim, but I think it's appropriate to recognize that. So that would be how I answer that question. But the victims are always in my mind in these cases because, we hear them testify. I hear them testify, and it's very powerful testimony, always.
They get their 2 minutes, and that's about all they get.
Okay, moving on to Delegate Pasteur.
Thank you, Madam Chair. Now, I heard what Ms. Duncan said, and I've spoken to Ms. Duncan prior to today, so I know the level of her angst. And I'm listening to the two of you, and maybe because I have a whole nother set of rules in my head about what should make folks look at you and who should be looking at you. But when I listen to the two of you talk, I'm a little confused, so I need to hear you be more definitive, because it sounds like, if you're this really good person and you've been working in prison while incarcerated doing a number of things and you've been there for a while, then you deserve these credits. But I know that there are other ways that it's almost, I just said to this delegate, it's almost like a math game. How many points do you have? So I need you to just explain that, because I'm not getting that same sense as I'm hearing you talk. It's like, how many points here, and then where do you go? Who makes that final decision, and what are they looking at? Please delineate that for me. For real.
So there are two main ways prisoners are released in the state of Maryland. One is the parole system. And if you're serving a life sentence for first-degree murder, you can get an earlier parole hearing based on the DIMS you've earned. So if you go months and months without infractions, and if you're working, and if you there are prisoners that have very, very important roles in the institution,
may I stop you, because that's not my question.
I'm sorry, I'm not sure I understood it, so.
Okay, you said the two ways, like going to parole, and when you go there, because you have all of these pieces lined up, I want to hear what those pieces are. Tell me the kinds of things that you can do to get those credits.
Okay, so that's a great question.
Not just going to school.
So the way it works in Maryland is that, particularly if you have a term of year sentence, you get good conduct credits up front. They're given to you, and then if you commit infractions, you lose them. So that's the first way you earn diminishing credits. And for a violent felony, you get 60 credits a year, prospectively. Immediately they give them to you, and then if you get infractions, you can lose them all. And believe me, there are clients who have lost them all. Because they are abusive to other inmates and to staff, because they have contraband. So it's actually very difficult to keep all your diminution credits. But on the other side, there are people that do that. Now, in addition to good conduct credits, you can earn industrial credits, which means you're working, and that's another 5 credits per month that you gotta earn going forward. You can get education credits, and then there's something called special project credits, there are some roles that are so important in the institution, like being an observation aide, where you're looking after other inmates who might be going through psychiatric issues. Those people get additional 5 credits. All in all, you're talking about, at best, around 2/3 of your sentence you're absolutely gonna have to serve.
Okay, so I'm just going back to, it's like an arithmetic. It's how many credits. It is literally credits, points. And if, let's say you come from another prison, okay, so are you going to start and everybody knows why you were there, now you're here? Are you going to start all over again? So it's start and stop. You can lose your credits, but then you could, on one side, build the number of credits you need, which does have some level of irritation for me. You can build those credits again where there's someone else in there who on many other very substantive levels that have nothing to do with credits and your good conduct at meals or on the yard or wherever, not have that same opportunity. I'm trying to understand these credits, but I think I have it.
Just so we're clear, everyone has opportunities to earn credits if you're in the Division of Corrections. So it applies to everyone.
No, I understand.
Except those that have already been excluded.
Right. It's still like a math, not even a math project, but arithmetic.
It is a bit of an arithmetic problem, that's true.
It is an arithmetic.
Yes, and just to add, if it's helpful, the Department of Legislative Services, they recently updated their guide on the diminished credit system. That was updated in October 2024, so we can circulate that to you all if it's helpful as well.
Okay, thank you.
Yes, please circulate that. That would be, I think that would be very helpful. Okay. Are there any other questions? Delegate Sample Hughes.
Sure, thank you, Madam Chairwoman. I'm going to try to frame this as a question. It's almost like I want to say to you, do you hear yourself? I'm not trying to be sarcastic, but I'm a little frustrated because outside of my legislative responsibilities, I work for a funeral home, and I'm always consoling families. Just on 2 weeks ago, I consulted a grandmother, sisters, all of them, because the aunt decided to kill the niece on New Year's while she was holding her baby. I could not imagine constantly giving this lady tissues, closing the casket, and then turning around and saying, oh, she's gonna get out early. I mean, do you understand the significance of this? That for me, the law is not play for me, and neither is taking care of families when they've lost their loved one. And I mean, you just gotta think about that woman, she's not coming back. She can't take care of her baby because someone decided to just kill her. I mean, so why did you think they deserve those credits? Do your time. I mean, you still get, that person still gets to breathe. They still get to walk this earth. You know, I don't know, that's just where I am, but I just want to make sure both of you hear yourselves.
Look, I mean, I represent people who've done terrible things, and there's no doubt about it. I think that we do need to differentiate between the person who really is remorseful, and I know that may be small solace to the victim, I get that, I totally get that. But the person who does everything right versus the person who does everything wrong, I think we need to distinguish between those two people, even though they've both done terrible things, and I agree that they've both done horrendous things, but I think we need to distinguish between the person who is really trying to turn their life around.
You know what, you need, I hate to say this, but you won't say that when someone comes to knock on your door and you're calling the funeral home asking us to come pick up your loved one's body. I don't care how right somebody's gonna be. They did this, they did that right. They're still breathing. They're still able to walk this earth. They're still able to get an education on the taxpayers' dollars, by the way. But that person that is deceased, they don't get that opportunity anymore. So, I mean, I'm in support of the bill. You can't convince me, but I just want to make the statement.
Excuse me, I don't know the format.
Okay, Ms. Duncan, I'm sorry. We actually don't go back and forth after you've had a chance to testify. I'm sorry. Thank you for understanding. I see no further questions, and Ms. Duncan, if you want to stay behind, if there's anyone you want to talk to, or if there's anyone of our members who would like to talk with Ms. Duncan, if you have the time, I'm sure we can allow for that. Thank you so much. I appreciate you all being here today.
Thank you.
That concludes the testimony for House Bill 374. We're going to move on now to, where are we going to move on to? Let's see. We're going to move on to Delegate Crutchfield. Delegate Crutchfield, House Bill 437. We have a panel. Okay, and the folks I have listed, I assume Debbie Feinstein will be virtual. We got Lisa Jordan, Joyce King, and I assume Mr. Scott Schellenberger will not be present. Is that correct? Okay, great. I got something right today. So Delegate Crutchfield, whenever you're ready.
Okay. First of all, I just wanted to say, I'm glad y'all are holding on. Just another 20 minutes, okay? Because it's getting late. But anyway, for the record, I'm Delegate Charlotte Crutchfield. I represent Montgomery County's District 19, and I am here to testify in support of HB437. So this bill is really simple. Actually, it's a little bit simpler than Delegate Williams' bill, in that what we're really trying to do is we're trying to add to a category that already exists of places where people should have a reasonable expectation of privacy when it comes to certain events that are occurring with them. And those events are specifically surveillance being prohibited in places such as bathrooms, such as offices, where there is a prurient intent. And so what we're trying to do is add a place that is the one place we should all have a expectation of privacy, and that is our residence. That is the only thing that is missing from this category. We forgot about that, and we, the legislature, need to correct that and make sure that people do and are able to rely on the fact that there will be no surveillance in their homes, okay? So what I'm gonna do is I am going to pass this on to my panel, but what I'm looking for is a favorable report on HB 437. Thank you.
Good afternoon, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 437, which you notice is a pared-down version of a bill that you have heard before. Previously, this bill has been offered with an additional criminal penalty. This year, that is not there. The penalty is staying exactly the same. But what this is doing is it's correcting a loophole in the law that fails to account for the privacy of a residence. And the impetus for this particular bill is really fairly shocking. There was a case in Caroline County, and a 15-year-old boy was taking a shower at a camp, you know, up in the mountains, and being mentored. There was an individual who was a judge. And the judge was mentoring boys and brought these young men up there. And the 15-year-old found a camera in the shower and reported this. And so the case was never brought to justice because the law enforcement did their job. They brought the judge to the hospital, and they got the camera out of the judge's intestines because the judge had eaten the camera. It's shocking. It's a shocking case. And then the judge died by suicide before he could be brought to justice. But that camp might not have been covered. And so this bill, that covers that loophole, because what if that's a home? We need to be able to prosecute that sort of case. For those reasons, we ask for a favorable report on House Bill 437.
Thank you. Ms. King?
Good afternoon, Madam Vice Chair. Joyce King on behalf of the Maryland States Attorneys Association. I'm actually going to use my 2 minutes to lift up the voice of Ms. Taryn Quaitman, who's sitting behind me, who's a survivor of this gap in the law. This is her statement. On March 24th, 2023, I had been happily living for more than a year and a half with my best friend, Kimberly, and her partner of 10 years, James. Yet one day later, I stood in the shower, naked and petrified, as the bathroom door opened and the camera lenses of James's iPhone slid into view. This this act is not isolated, Kimberly later discovered a note on James's phone unveiling video after video of me in the shower and on the toilet. I went to the police, hopeful that although I failed to protect myself for the 15 months James had filmed me, surely the law would. 17 months later, James was found not guilty on every count of visual surveillance. There are a minimum of 29 videos and 65 images of me, yet James's predatory behavior was disregarded due to a semantic technicality. A precedent was set. In Maryland, recording someone naked in their own bathroom without consent does not violate the visual surveillance law. The rationale, the law does not explicitly list a residential bathroom, presumably one of the most private places imaginable, as a private place. The law failed to protect me, and it will fail to protect future victims, but it does not have to. We have a beautiful opportunity to make it better. This bill is fair. It clarifies that given list of private places is not exhaustive and eliminates ambiguity. The bathroom in your home is private. I urge you to vote for a favorable report and to consider the tremendous impact that will come from such a simple change.
And Ms. Feinstein.
Thank you. Good afternoon, Vice Chair Bartlett, members of the committee, Debbie Feinstein. I'm with the Montgomery County State's Attorney's Office, and as well as co-chair with Ms. King of the Maryland State's Attorneys Association Special Victims Committee. The statement that Ms. King read came as a result of really an injustice that happened in Montgomery County just a few short months ago. The defendant in that case was charged with 23 counts of visual surveillance with prurient interest, private place, and was acquitted of all 23 counts of visual surveillance in a private place, simply because the definition did not include private place. The state's attorney argued not only that the defendant should be guilty of visual surveillance in a private place because it was simply a private place, but then also argued under a separate part of the statute that says basically anyone that has a reasonable expectation of privacy, regardless of whether it's a public or private place. The court said that didn't apply either because the definition of private place in the statute did not specifically delineate a residence or a bathroom in a residential home. By adding residence, by adding this definition to private place, we close that gap and we bring justice to individuals like Ms. Quaitman, who really suffered an injustice because of a few words that were missing from a statute. It really doesn't make any sense not to include residence as a private place in a home, a residence as a private place, and we would urge this committee to issue a favorable report. Thank you.
Thank you. Are there any questions? I have one question. How many times has this bill been brought to our attention? Was it just last year? I thought it was more. Yeah, that's what I thought. Okay. Okay. Great. Okay, Delegate Cardin.
To the state's attorneys, is there a constitutional right to privacy that you could use that doesn't exist in the statute but exists in the Fourth Amendment?
I'll defer to my colleague, but I don't believe so.
I don't think that there's a constitutional right that would then, if it's violated, result in a criminal charge. This is the criminal charge that enforces the idea that you have the right to privacy in your home. And we just saw a situation that made no sense in our courts, but looking at the specific law, realized, you know what, it's not delineated.
And just a quick follow-up, Madam Chair, is there, is Maryland an outlier, or the Maryland courts an outlier in this decision? Has this decision been different in other, or it doesn't even exist in other states? Because they didn't forget to put residences and bathrooms into the statute.
That is, I will highlight that this isn't just a Montgomery County ruling, that when we polled other jurisdictions, they were facing the same issues. But it's
crazy. Okay, thank you.
Great, thank you very much, panel. We have one person testifying unfavorable, I believe, Ms. Holland. Not Ms. Holland, I'm using your first name as Ms. You may begin whenever you're ready.
Thank you. Good afternoon, Chairman and members of the committee. Once again, my name is Holly Brownlee. I am an assistant public defender in District 3 on the Eastern Shore, and we respectfully request an unfavorable report on this bill. Criminal Law Article 3902A lists 9 types of private places in public areas that a person can reasonably be expected to be disrobing in and which has a reasonable expectation of privacy. This bill would seek to unnecessarily expand this list of private places to include a residence and any other place of private use or accommodation. Subsection C of the statute already provides criminal penalties for conducting visual surveillance of a private area of a person without their consent, quote, regardless of whether the individual is in a public or private place. So I'm really not sure what the loophole is. In preparing this argument, I came across an Appellate Court of Maryland decision from 2018 in which the court noted, the state suggests that this interpretation would mean that the statute, 3902 that is, would mean that the statute protects individuals from being recorded while using public facilities, but not individuals in a bathroom within their own private residence where one would normally expect to have the highest level of privacy. The state overlooks subsection C2 of the statute, which is focused exclusively on surveillance of an individual's private area by the use of a camera. The General Assembly did not limit C2 by the location of the surveillance. So while I'm very sorry that that happened, I'm left to wonder, did the state only charge under A? Did they not see C? I think the statute's pretty clear. The Appellate Court of Maryland thinks it's clear. My concern is adding new provisions that are unnecessary, overbroad, and potentially open the door to criminally charging otherwise innocent behavior. As far as the late Judge Newell is concerned, I am going to take that up just for a second because that is my backyard. That absolutely, I think, would have been considered sexual exploitation under the 25-year existing sex abuse statute. So there are already a lot of things that are covered, and we don't need overbroad, unnecessary terms. I think there's other ways to address this issue across the state. I think the appellate court has been clear, and I think the statute that the General Assembly came up with initially is clear.
Thank you. Any questions? Delegate Williams.
Yes.
Yes.
Thank you, Madam Chair. I guess you're saying the statute is clear, but we have very clear examples of actual cases where the courts have ruled otherwise. And so it seems as though, while it may be clear to you, it's clearly not clear to our friends in the judiciary, thus the need for the legislative fix.
I could see what the problem, what I can say, I've been a felony trial attorney for like 16 years. The first thing I'll say is judges do what judges do. And so different judges are gonna do different things. I guess the question is, do you try to clarify something and potentially create more ambiguity in the law and capture otherwise innocent behavior simply because you've got some judges doing random things when you have existing case law and existing statutes that specifically say that if somebody records somebody in a private area, records a private area of a person without their consent, regardless of whether they're in a public or private place, I don't understand how you could be clearer.
Right, but clearly there's ambiguity in the law, and if it's just a random situation that is not a violation of someone, then obviously a good judge will see that for what it is. And I mean, if it's a jury trial, then a good jury hopefully will see the facts for what they are and rule accordingly. But clearly there's an ambiguity here. I mean, we're not just talking about like one random case here. And so I guess I'm just really finding a hard time understanding the argument against.
Well, what I'm curious about, what I haven't heard, I heard this previous last week in the Senate, what I haven't heard is exactly what the situation was with this unfortunate victim whose abuser was acquitted. I'm curious. Again, I'm looking at that immediately. I'm thinking, were they just charged under A and the state thought they had it and they could just get through and then it didn't? That's my immediate thought on that. As far as the late Judge Newell, I guess we'll never know on that, but I'm 100% confident that that's sexual exploitation under the sex abuse statute. I worry about situations where, suppose you have a nanny cam, suppose my baby monitor, which I do have for my 7-year-old son who sleeps on a different floor, am I gonna get in trouble someday? I know you get back to that idea of the prurient intent, but yes. I'd hate to be charged and then have to come up with that, you know, as my defense in the end. I worry about over-criminalizing behaviors that maybe come from an innocent place, simply to clarify an ambiguity that I'm just arguing I don't think is truly there.
Right, but I think the intent also has to be there as well. But anyway, those are all my questions, Madam Chair.
Thank you, Delegate Kaufman, and then we'll circle back to Delegate Simpson.
Yes, and thank you for staying with us all day. You've indicated, you've given one example using yourself of of an innocent behavior that somebody could get busted for the nanny cam type of stuff, or baby monitor type of stuff. But because of one example is not a good reason to not pass a bill, especially given the abhorrent behavior we heard about from the proponents. So can you give other examples?
Sure. Suppose you have, we all love the Ring cameras. I see a whole bunch of them when I'm defending my cases. Suppose you have a Ring camera that you are keeping in your house and somebody's disrobing in an area. Are you in trouble? Are you in trouble now? Again, these are situations where, yes, you get back to that prurient intent, but does that stop somebody from saying, oh, well, they were doing it in a, to be lascivious. They didn't know I was changing, they knew I was going to be changing in this particular area in my home or something. And meanwhile, maybe it's just your Ring camera that you have in your home, or maybe you have it for safety reasons, that's pointed towards, out your door towards other people's houses. And what if you can see in there? It's hard to get specific, except that I think that there are all kinds of different ways that you're encapsulating more behaviors simply to try to address an ambiguity that I think maybe more detailed case law research would help with these matters.
Can I ask a brief follow-up, Madam Chair? Thank you. But I'm not a lawyer, but I watched enough TV, and I'm well read to know that the standard is you have to prove guilt beyond a reasonable doubt. Mm-hmm. So if in fact it's innocent behavior, if the defense attorney's worth his or her salt, can't they raise enough doubt potentially to address something like that you didn't realize that someone was disrobing or something? Isn't that what a trial is for? So if in fact somebody is indeed, if it can be demonstrated it wasn't period intent, that's what good lawyering is about.
I'm here to tell you that with regards to sexual offenses, the real rule is you got to prove yourself innocent. And I don't know a single defense attorney who would disagree with me on that. Whatever the law says.
Delegate Simpson.
Wow. Well, hard to follow that one. I would strongly disagree with that last statement. I do appreciate that you've come to testify, and I do appreciate that you feel that it's confusing, and that I do appreciate that you have said that you feel that it is clear to you, and clearly you're not a judge yet, and you wouldn't be everywhere. So wouldn't you agree that the fact that there still is a General Assembly, and there still is a committee called Judiciary and one across the street, indicates that it is necessary for us, when these cases come up and there is ambiguity or it is not clear, isn't it our role in order to determine what laws need to be put in place so that it is clearer to those who are carrying them out? Isn't that our purpose?
Well, for example, I think one way you could do it with this statute would be to simply say that with regards to the existing subsection C, that subsection C2, the private area of an individual by use of a camera without the consent, would not be visible to the public regardless of whether the individual is in a public or private place or residence.
So we have several examples, and we have several experts whom I give. Delegate Crutchfield is just absolutely incredible in the amount of research and information that she puts into her bills, and making sure that she checks with all those that are listed to make sure that this is something that is going to actually take care of a problem. So a problem has been identified, and we as a body have a responsibility to make sure we provide that clarification to those to whom we serve, which includes the judiciary, which includes the attorneys. And when we have a victim, it is our role. I mean, I definitely will not agree that, you know, all of our sex offenses is that they are just defending them. That's not happening. I mean, how many people walk away? So there's been ambiguity. It wasn't one case, it's several. It's not just one area. It's not one jurisdiction. So when things are happening throughout the state, the Maryland General Assembly and then this committee has a responsibility to figure out how to solve that, especially if we're going from the research and the information that's out there. If this is what they're asking for, and the judiciary is not coming and saying they don't want this, shouldn't we provide them with the clarification so that victims, such that we've heard from, can receive the justice that they deserve? It wasn't accidental. These cases weren't accidental, correct? They were very clear that this was intentional, which is what our other delegates have pointed out. I mean, otherwise we'd be disbanded, right? The law is not good enough that it wasn't able to protect these individuals.
So the proposal I'm aware of is to take a section that clearly lists 9 types of private places that are in public areas and shove in something that is clearly a private residence when there's already an existing subsection that covers all places. My suggestion would be that if we really want to do that, we should simply add in under subsection C2, so the judge that I guess somehow thought that public or private place was confusing, you could say a public or private place including a personal home, instead of trying to just shove in something that doesn't otherwise even fit the category, simply to address something that may have happened in a couple instances. I don't see how that's not a better fix, rather than trying to put it into a category where it doesn't make sense and doesn't fit.
Once again, we really do appreciate your input and that you feel that it is a better place. We also have a responsibility to put it where those who are going to be acting on it feel it's the best fit. And if at the end of the day, it works to relieve, you know, this situation. I can't believe that this is just a couple of times that this has happened, that a victim has come forward, said that they have been recorded, which we can't even believe that this is okay when, you know, we have this wiretapping we just heard about, and they would have committed a felony, but then it's okay in a private place to intentionally, and because this isn't in here, and that's what we're trying to fix, so that somebody is able to know that this is not okay. That's our job, right? To put together laws that say this particular behavior is criminal and not okay, and please stop doing it.
I just don't think it should be at the cost of the statutory language, simply to make a fix. I think maybe let's talk to the state's attorney who did that case. I mean, that's what I'm thinking, that got mischarged. I've had plenty of this type of case, and I haven't had, I mean, they've certainly been prosecuted for this. I'm not aware of this ambiguity in the law, and I just would like to make sure the committee is careful not to over-criminalize other behaviors just for this one fix.
And I understand that, but this isn't law school. This is the Judiciary Committee, and we are trying to fix something in order to give victims, you know, some relief. And this is what they have said.
Okay.
Isn't that so?
Isn't that so? All righty. So that concludes the testimony for House Bill 437. Everybody, we all get a chance to have our turn to say what we need to say and ask what we need to ask. so we're going to move on to House Bill 364, last bill of the day. And speaking of getting your turn, Delegate Simpson, this is for you. This is for you. And we've got a panel. Good to see you, Gavin Potashnik. Come on down. Zachary Payne, Lisa Jordan, Joyce King. Come on down. All right, you all, this is our last bill of the day. Keep that in mind. It's on you, Delegate Simpson. Ours too.
All right, so I'm going to be quick because I'm going to turn it over as you to the experts to give this, some teeth. Is that I did like earlier when we were talking about Delegate Wilson's bill, Chair Wilson's bill, that this is actually child sex abuse material, and we should be thinking in those terms. Because we know, all of us are aware, that there is a trend of child pornography decreasing in age that's brutal, depicts violence and abuse, and we've got to do something about it. And this is not, I think often folks think this is a victimless crime because they think they're photographs or pictures. I can't understand how anybody would want to keep this in a misdemeanor when we are talking about children being abused. And so with that, I hope you will give it a favorable vote, and I will turn it over to the folks to my left and my right, who are the experts.
Good afternoon, Madam Vice Chair, members of the committee. Gavin Potashnik. I am the Chief of the Special Victims Unit in the Cecil County State's Attorney's Office, asking for a favorable result of House Bill 364. I thank Delegate Simpson for her leadership in this category. So what this bill essentially does is it tries to hold accountable and has a delineation between people who have some images and the collector of CSAM material. And again, both are bad. We're not saying that one is better than the other, but there needs to be a different mechanism to hold the collector accountable. There are individuals now, we're seeing it more and more, and my colleague, Mr. Payne, and I also see it in the Cecil County State's Attorney's Office, where people have not just 1 or 10 or 20, but hundreds and sometimes thousands of images of CSAM that runs the gambit from child erotica all the way up to some of the worst things that you can possibly imagine. As prosecutors, we have a legal responsibility to see it, and we do. And let me tell you something, there needs to be a separate type of penalty structure and separate type of crime that deals with somebody who collects this material, thus proliferating the industry that uses children in this matter, versus somebody who has a few, which again is bad, but there's already a mechanism in place. I would also note that oftentimes the same penalty can be applied to somebody who has thousands of images versus somebody who has 1 or 2, and that charging decisions need to be different for that type of structure. So I ask this committee for a favorable result, and I will turn it over to the right member of the panel. Thank you.
Good afternoon, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in strong support of House Bill 364. My colleague, Mr. Potashnik, has already eloquently described the issue with having over 100 images of child pornography. However, there's a second part of this bill. This bill also increases the penalty when we have an image of a child that is or is indistinguishable from a child under the age of 13 years old. And just think about that for a moment. We have not only an industry of child sexual abuse material, but we have a whole separate category of extremely young children. These are vile images. I'm not going to repeat in this setting all of the different things that can be portrayed. But these children, they're especially vulnerable, and they will go for the rest of their lives wondering who else has seen this image. Most of them will never see justice. Most of them will never see compensation. Most of them will really simply be haunted by the fact that when they were extremely young, someone sexually exploited them. The age of 13 is an age that's used throughout the code, so we use that in our tender years statute. It's also relevant in our juvenile law. So this is a reasonable demarcation line to say when the images are portraying a child that is especially young, we need an especially strong punishment. For these reasons, we ask for a favorable report on House Bill 364.
Good afternoon, Madam Vice Chair, members of the committee. My name is Zachary Payne. I'm an assistant state's attorney in the Cecil County State's Attorney's Office, working directly under Mr. Potashnik. I would also Yes, ma'am. My apologies. Good afternoon, Madam Vice Chair, members of the committee. My name is Zachary Payne. I am an assistant state's attorney in the Cecil County State's Attorney's Office. I work directly under Mr. Potashnik. First, I would like to thank Delegate Simpson for her strident leadership on this issue. I am also here requesting a favorable report on House Bill 364. I have been doing these cases pretty much the entirety of my career in the Special Victims Unit by dint of having a more facilitation with some of the technology when I started, as well as a particular passion for this work. Doing the research and help proposing language for this kind of bill, we went through some of the other states, and there is a significant commonality across the board and across the country for an enhancement of child pornography possession based on quantity as well as based on age. I can cite California, Colorado, West Virginia, Hawaii, Illinois, Indiana. I would also note that the federal structure, while not specifically delineating additional penalties or enhanced penalties for quantity or age, the federal structure in the sentencing guidelines does provide for an enhancement of the penalty scores for possession, and they actually have a nuanced scale from 50 to 100, you add points, from 100 to 200, you add points, and up and up and up. But it is designed to address what Mr. Potashnik noted, that there is an increasing amount of proliferation of these images simply by nature of the technology. A terabyte of data is what we're dealing with regularly with these cases, and to put in perspective, that can hold 250,000 images, 500 hours of high definition video. As to the re-victimization, I would note that there is a structured reporting through NCMEC as well as for these federal cases that every single time one of these images that are tagged as known, there is a report to the representative of that child if they actually put their information in. So not only one re-victimization, but some of these victims and survivors are told every time that image is proliferated. Again, members of the committee, Madam Vice Chair, we thank you for your time and request a favorable result on HB 364. Thank you.
Good afternoon, Madam Vice Chair. My name is Joyce King on behalf of the Maryland States Attorneys Association. I echo the sentiments of my colleagues and thank you, Delegate Simpson, for championing this important topic. I've been before this committee since 2019 advocating regarding child exploitation bills. And just for some data points, the National Center of Missing Exploited Children put forward a report. There are 36 million cyber tips a year. That is 105 million images circulating the internet, and that is 20,000 new series. That means new content is created a year in this industry of child sex abuse material. We do these presentations in schools, we tell the kids that's one every second. That's how often and how prolific these offenses are happening. And so it is so important, and having done this work and running a task force that is regarding child exploitation, we have looked at so many devices, so many phones, so many computers. There is undoubtedly a difference between someone who has 1, 2, 10 images versus someone who has 100. And in my last case had 1 million images. It is a different type of offender, a different threat to public safety, and it should be treated differently in the law with penalties. I went before the Maryland Sentencing Commission in 2020 to advocate for an increase, a point increase, that we acknowledge the permanent injury in these types of cases, and the Sentencing Commission agreed. And I know that it sometimes is difficult to make something a felony, but just to put in perspective, the 10-year felony is the guidelines are probation to 2 years with no points if it's not a vulnerable, if it's not a child under 11 or 12, and 3 months to 4 years. So, I mean, those are the guidelines for these types of offenses, and I just wanted to highlight that perspective. In the last 10 seconds, I will say, in my million image case, the only reason the feds took that case is because I'm, 1, cross-designated as SASA, and my jurisdiction is set up for it, and 2, they found 3 images of production. Had it not been production, that would have had to remain a state case, and that's why we need this type of enhancement on the state level for other jurisdictions to enforce it.
Thank you. Thank you for your testimony. I have a couple of quick questions, I hope. One is for Mr. Payne or either Mr. Potashnik. Is the minimum 100? I mean, I know that we've got different, if it's a photograph, it's considered 1. If it's a video, it's considered 20, et cetera. But is it 100?
So, Madam Vice Chair, just to explain a little bit, so there is a big difference between a singular image and a video, right? So a video, the way that this bill contemplates it, is declared to be 20 images, which makes sense because actually for each second. And the way these images are transferred from one to another, there's a data packet of information that goes from, from the internet to somebody's device. And in some ways, the way you can send this is you can send it by particular images, think like a flip book. So if you send a flip book, right, and then your computer reassembles that into a video, what is that? Is that one image or is that more than one image? In this bill, it contemplates more than one image so that we can adequately address what we're seeing, which is more and more videos because bandwidth is getting bigger. And this is a roundabout way of saying, yes, it's 100 images, but there are ways to calculate that to address how these things are being sent and how these things are being managed by the collector kind of individual that we're targeting.
So the reason why I mentioned Mr. Payne, because you mentioned a state that has an accelerated system. Can you repeat that state?
California is one of the stronger statutes for calculation of images, as well as for enhancing and doing a image, for basing the enhanced penalties on the number of images, as well as understanding a video file as a series of images. Mr. Potashnik is absolutely correct that all a video is a series of images, one right after the other. There are 1,000 free softwares out there that can take a video and break it up into one image each, do screenshots. There's even software that will create a little movable picture called a GIF from a larger video, and I've actually prosecuted a case where a child pornography GIF was sent. But California is one of the states that does have a particular contemplation of the videos as images, but also a methodology for calculating the total number of images an individuals possess under that kind of statute.
I guess what I was getting at was, I thought you said there was a state that looks at 50, this is the penalty, 100, this is the penalty, or something like that.
Oh, that would be the federal sentencing guidelines. So they have points increases for the number of images possessed.
Okay, and so then that goes to my question that I was going to ask Ms. King, and that is, how do we look at this on a federal level? But I guess what Mr. Payne just said answers that question.
That's correct.
Okay.
And I did bring that up at the Sentencing Commission, and unfortunately, our guidelines aren't able to account for that. And I advocated for that, and that's why we're here today, is because initially we wanted to just do enhancements for quantities as well as infant, toddler, BDSM, which is what the federal statutes do, but they were unable to do that.
Thank you. I see no further questions. So that ends the testimony for this panel. We have testimony unfavorable, Ms. Vanita Taylor.
Good evening. Vanita Taylor from the Office of the Public Defender. I am your last person of the day, and you will be released to your family and homes after this. The Public Defender's Office is in opposition to House Bill 364. We will be requesting an unfavorable report from this committee. Basically, enhancements are really double duty. Enhancements also contribute to overcharging of individuals. In fact, it's not even necessary in this instance because of the fact that I will tell you about a case, TURENE versus State, September 2023, number 20. It came out in August of 2024 from the Supreme Court of Maryland, where a woman had taken 8 pictures of a child's genitalia. She claimed that it was to see if there was a diaper rash. She did not win that argument and was sentenced to, I will tell you, 280 years. all but 126 years suspended. She got more time for taking pictures of a child's genitalia than she would have if she had murdered someone. Enhancement penalties do not make us safer. All enhancement penalties do is increase the time that someone will be incarcerated. And in this bill, even an enhancement is not tied to, as this panel before me said, it's not tied to any actual physical or mental harm to the child. It's not tied to anything other than the fact that there were 10 pictures as opposed to 2 pictures. We request that this bill be granted as unfavorable. We do not believe it is necessary, and we believe that it would only lead to overcharging of Maryland citizens.
Thank you. Are there any questions? Are you ready to go? Oh, okay. Delegate Erican.
I am ready to go, but that was such a disturbing story. Because, of course, you know.
It was disturbing to me, too.
Yeah, so who did she share? What was, can you give us some more context? Because I'm imagining like mom groups, and I've definitely seen people like, oh, let me send you a picture of my kid's rash. I'm like, don't do that, thank you so much. But like, people don't know.
Yes, people do not know. And in this instance, it was a woman who was a daycare provider down in Wicomico County, and she was taking pictures of a child's genitalia. She said it was because she wanted to be sure about a diaper rash. But unfortunately for her, she also had some adult porn on her phone as well.
Huh.
And because of that, she was convicted of sexual abuse as well as child pornography. And she was given 280 years, all but 126 years suspended.
So she's still in prison now?
So she is still in prison now. This just happened. The case went up on appeal in 2023.
But no other evidence prior that she had?
No.
And on no other devices were any child pornography found?
No, but she did have pornography.
Well, I assume illegal pornography, not criminal possession of.
I don't recall.
Okay.
But you can. It's the cases of public record.
Okay, I'll have to look into it.
And she got a lot of time, and people don't realize that. They take pictures.
This is a PSA to anybody listening. Do not take pictures of your children's genitals.
Yes.
Just don't do it.
Yes.
Just go to the doctor.
But the problem with that is that you have to realize is that because now we do telemedical.
Oh, yeah.
People send pictures because you're doing telemedical. You're not coming into the office. So it really is a interesting world that we live in now.
Yeah, this is getting weird. Yeah, thank you.
Today. Thank you.